Hello everyone. Today we're going to do a hearing, something new that we've never done on this channel. We're going to have a hearing that takes place in Arizona. This is for a man who is seeking commutation of his death sentence, which is scheduled just days from the time of this hearing. His name is Robert Towery. I'm not going to tell you the results of the hearing. You can of course Google it and I'll include the links below, but if you don't want to know the outcome, you want to go through it, you can just watch it through. Special thank you to Lisa for sharing this case with us. With that, let's jump into it.
Good morning. Today's date is March the 2nd, year 2012. This is a meeting of the Arizona Board of Executive Clemency. We're at the Arizona State Prison Complex Iman Reining Unit, and we are here today to hear the request for executive clemency on behalf of Mr. Robert Towery, DLC number 51550. There are two things that we'll be considering today, and they would be, number one, Mr. Towery's request for a commutation of his sentence, after which we will then take a vote on whether or not a reprieve of Mr. Towery's scheduled execution should be recommended to the governor. And the time now is 8:45, and we will begin. And sir, you are Mr. Towery, is that correct? Yes, sir. All right, thank you. And is that your correct DOC number? Yes, sir. 51550. Thank you. Okay, you can be seated here. And we will turn now to Mr. Bates. Mr. Bates, will you be, or? Ms. Day. Okay, all right, thank you.
Thank you, Peach.
Good morning, Chairman Belcher and members of the board.
Good morning.
My name is Therese Day. I represent Mr. Robert Towery, who is here this morning to request that the board hear his plea for commutation. We do not have a request for reprieve today.
Okay, thank you.
With me are Dale Bache, Kelly Schneider, and Natasha Merle, who also represent Mr. Towery and who will also be presenting portions of this hearing today. I would first like to thank the board for coming to the prison today to allow Mr. Towery to be present. And I would also like to thank the warden, Deputy Warden Barrios, and all of the prison staff for their efforts in making this hearing happen this morning. As a preliminary matter, we would like to ask the board to respond to our letter of February 17th, in which we requested that Mr. Towery be allowed to sit with his attorneys at counsel table rather than to make his plea for commutation from a cage. Okay. And Mr. Belcher, if you wouldn't mind responding to that at this time.
All right, thank you. No, I would not mind at all. Once in receipt of your letter, being that the Department of Corrections obviously allows us to have clemency hearings at the state prison, the logistical setup of these hearings is totally 100% within the jurisdiction of the Department of Corrections. I did take the liberty to forward your letter, and I also had received a letter from, I can't think of her name, Mr. Mormon's attorney. Okay. Basically, somewhat identical request that they be allowed to sit at the attorney table. I submitted those to the Department of Corrections, and those requests were denied by the Department of Corrections, and that's the status.
Okay, thank you, Mr. Belcher.
Thank you.
And also, we appreciate the consideration of both you and the DOC. However, we still would like to note that we believe that at this type of proceeding, our client should be able to sit with us at counsel table, and we hope that the DOC would take that into consideration for the future.
Okay, thank you.
We've presented our application to the board, in which we have listed several reasons why we believe it would be appropriate and just to commute the sentence of Mr. Towery to life without the possibility of parole. Mr. Towery's family is here today to offer support to him in this request. We know the board has received our application and has reviewed it. Our presentation today will focus on the following issues. We will first provide a brief explanation of Robert's family history and background, and will explain to the board what Robert's state of mind was at the time of the crime, which was due in significant part to his severe addiction to methamphetamine. You will then hear from Mr. Towery himself, who wants to apologize to the family of Mark Jones for taking Mr. Jones's life and for the pain that it has caused Mr. Jones's family. He will admit his guilt to the family of Mr. Jones today, and he will do his best to explain why this horrible crime ever occurred. We will explain through the testimony of Dr. Pablo Stewart why Robert's background, in combination with his extreme addiction to methamphetamine, led to the tragic death of Mr. Jones. We will briefly discuss Robin's prison record and why his good behavior in custody is a strong indication that he does not pose a risk of violence in the future should this board decide to commute his sentence to life without the possibility of parole. We will briefly describe how the legal system failed Robert, because at the time that he was sentenced, the law in Arizona did not allow his sentencing judge to consider his evidence of childhood abuse, and how you, the board, may consider this today in deciding whether his sentence should be commuted to life without the possibility of parole. Finally, we will explain why Robert's death sentence is disproportionate given the nature and circumstances of this crime, and the fact that his co-defendant, who was a major participant in the crime, received a sentence of 10 years in prison rather than death and is a free man today.
Okay, thank you, ma'am.
Thank you.
I'm going to talk to the board a bit this morning about Robert's childhood. I'm going to leave it to Dr. Pablo Stewart, who will be speaking to the board in a few minutes or shortly, to explain the impact of Robert's childhood filled with abuse and addiction on the man he was and the person he is today. For my part, I would just like to give the board some context to help understand Robert's life. Robert's home life was.
Just your name and.
Oh, I'm sorry. I'm Kelly Schneider. I'm with the Federal Public Defender. I'm one of Mr. Towery's lawyers. Apologize.
You might have said that, and I might have missed it, but.
No, I didn't.
Okay, thank you.
Robert's home life wasn't something that most of us have experienced or could imagine. It wasn't filled with love and affection, the things that we know build a happy and healthy child. Robert's world from the time he was a very small child was filled with violence and abuse. Robert's mother mentally tormented him from the time he was a child until he was a grown man. Robert's mother would say things like, "You'll never amount to anything. You're worthless. I hate you. You should have died as a child." And she would say those things to him on a near daily basis. Robert's mother beat him mercilessly and punished him in horrifying ways. She hit him with whatever was handy, belts, coat hangers, with little rhyme or reason. Robert's about 6 years old in this photograph. This is the year that Robert almost lost his leg to his mother's discipline. He'd been playing with his sisters in a wagon and had fallen. He hurt his knee, limped throughout the day, and it got progressively worse. His mother thought he was faking the injury and punished him. She punished him by having him kneel in a box of raw rice on that bad knee while the family had dinner, ate ice cream, watched television. It was hours. By morning, his leg had swelled to 3 times its normal size. He wound up in the hospital and nearly lost his leg. 6 years old is the same year that Robert was anally and orally raped by a neighbor boy. He would lure Robert into the family's bomb shelter where all the children wanted to play. He would tell Robert that the door was magical and he would have to perform a sex act to get out of the room. I asked Robert if he'd ever told anybody about this abuse, and he told me not until his 20s. I asked him why he hadn't told his mom, and Robert said he was sure he would have gotten in trouble. He reminded me that she used to beat him when he had to go to the hospital to get stitches, that when he was shot by a stray bullet in the alley behind the family's home as a child, he was punished for that. He was sure that if he told, he would have gotten in trouble. It was also at this age 6 when Robert started to drink alcohol. He would bartend at his family's weekly poker games, dropping off drinks to the adults and picking them up when they were through. He would finish whatever was left in the family's kitchen. Robert's about 8 years old in this picture. This is around the time that Robert's mother bound and gagged him and stuck him in the floorboard of the family's car. They were on their way home from a family trip, and Robert was simply being too loud. His sisters watched, too terrified to help him, as he cried himself to sleep. Robert's 12 in this picture. He was still wetting the bed at the time, and that should be a significant trigger to this board because most children stop wetting the bed around age 5. But children who are sexually and physically abused often demonstrate this regressive behavior. Rather than helping Robert with this problem, his mother would humiliate him. She screamed bedwetter at him in front of his friends and his family. She also hung his stained sheets over the bushes in the family's front yard so that when he came home from school with his friends, he would have to pass them utterly humiliated. 12 was around the year that Robert's parents divorced and his dad left his life. Abandonment became a central theme for Robert as his sisters left in the short years after that. 12 was the year that Robert found out that the man he'd always known as dad wasn't his father. Instead, the man he'd grown up knowing as Uncle Chuck was his biological father, and his mother banished Mr. Towery from his life. 12 was the year that Robert started to smoke marijuana, to feel normal, to feel something. And it was around this same time, 12 or 13, that Robert's mom expected him to start helping to support the family. But how could a child get cash to help support a family? How was a 12-year-old going to come up with $400? Getting money to help support his mother and his drug habit led to a lifetime plagued with theft. By 15, Robert's mother had thrown him out of the home. He was costing her too much money. He was using too much electricity, eating too much food. Robert would sneak into the home in the mornings to take a shower, change his clothes for school. He found a note one morning telling him not to return, but he came back the next day, and his mother had him arrested. That was the very first time Robert spent a day in a juvenile detention center for a crime, when his mother had him arrested for coming home to change clothes for school. By the time Robert was 17, he was an addict. He'd used virtually every drug you could think of: amphetamines, barbiturates, marijuana, angel dust, coke, LSD, methamphetamine. He'd overdosed once. It's at this point that he was placed in the drug treatment unit of a juvenile detention facility. It's significant that Robert became an addict as a child before he could consider the costs and risks of his drug use. The early age at which Robert began using drugs significantly increased the likelihood that he would be an addict as an adult. Robert was already addicted to the drugs as a child before he could fully understand what he was doing and the impact of the choices he was making. But I think it's while Robert's in this drug unit that we all catch a glimpse of who Robert could have been. He got his GED. He encouraged other students and helped with their academic efforts. He was a leader in 2 substance abuse programs. He was a responsible role model, according to the staff. He helped write the unit's newsletter. And the staff said that his repeated efforts on behalf of himself and others indicated much personal growth. Away from the drugs and away from his mother, Robert flourished. But when his time was served, he had nowhere else to go but back to his mother, back to the abuse, back to the pain, and ultimately back to the drugs. By the time of Mr. Jones's death, Robert's drug habit had increased to between 3.5 and 7 grams of methamphetamine a day.
Thank you, ma'am.
I'm going to now talk a little bit about Robert's state of mind at the time of the crime. At the time that Robert killed Mr. Jones, he was severely addicted to methamphetamine and was using this drug in combination with other illegal drugs. People who knew Robert at the time told police investigating the crime that he would often stay up for days on meth. He also shared this fact with Dr. Jack Potts in a pre-screening evaluation early on in his case. At his trial, Dr. Bayless offered testimony about Robert's drug addiction and his state of mind at the time of the crime. Dr. Bayless is a forensic psychologist who's experienced in working with addicts and substance abuse treatment. In meeting with Robert, one of the things that struck Dr. Bayless most was the fact that in his many years of working with addicts, he was surprised that Robert was still alive, given the amount of methamphetamine that he was doing. He stated, "I've had a lot of experience in working with substance abuse and substance treatment. And I have to say that Mr. Towery is one of the lucky young men because he's not dead. He was using so much drugs that it is incredible. His drug of choice was methamphetamine, and he was using it intravenously." Dr. Bayless testified that the amount of meth that Robert said he was using was corroborated by his girlfriend who lived with him at the time. He used anywhere between 3.5 grams to 7 grams of meth a day. Dr. Bayless said, "That is an extreme amount of methamphetamine to inject into your system. Anyone without a significant drug habit, that would probably kill them." Dr. Bayless also noted he was using cocaine and marijuana and sometimes mixing meth with cocaine together. He also used heroin, magic mushrooms, peyote, and LSD. Dr. Bayless continued, "Mr. Towery's addiction was so severe that he would take bladder acid and dilute it in water, draw it into a syringe, and inject it. Mainlining LSD is pretty incredible." Dr. Bayless explained what the effects on someone taking this level of drug and combination of drugs has. A person doing these kinds of drugs is self-destructive, and their judgment is markedly impaired. You become paranoid, delusional, you become violent, unpredictable, angry, hypersensitive, hyper-irritated. You will often perceive threat where such does not exist and become very bizarre. Dr. Bayless also testified about the addictive nature of meth and how it causes physical addiction, which means that the person's body becomes adjusted to this abnormal state and cannot function if that level of drug is not maintained. He explained, "Methamphetamine stimulates the pleasure center of the brain, and a person will almost use this to the exclusion of everything else. They will often go without eating, sleeping, and have one obsession in mind, and that is to utilize that particular drug." Dr. Bayless noted that this man is significantly addicted. There were periods of time when Mr. Towery would go 2 weeks without sleep, utilizing the drug, causing irritability, bouts of paranoia, and suspicion. Dr. Bayless also noted that this had a significant impact on Robert's state of mind at the time of the crime and his inability to exercise any reasonable judgment. He had impaired judgment and did things that simply were irrational and certainly drug-induced. There is no question that this level of methamphetamine caused Robert to become paranoid. Paranoia is a delusional disorder which causes you to think that everyone is out to get you or do something to you, to hurt you, to destroy you, to plot against you. Dr. Bayless also explained how damaged Robert's thinking was at the time of the crime. At the time in which this crime happened, the level of drugs which Mr. Towery was using would have significantly impaired his ability to do anything. I think that his ability to differentiate, to make rational judgment, to consider consequences was markedly impaired, as well as his ability to create a logical process of looking at what he was doing. When you take this level of methamphetamine, it just alters your personality totally. Dr. Bayless concluded by stating that at the time of the crime, Robert's ability to reason and exhibit judgment was severely impaired. He stated, "Understanding the nature and quality of his actions and right and wrongfulness was markedly impaired."
Thank you, ma'am. Good morning.
Good morning, Mr. Chairman. My name is Dale Bache. I'd like to introduce the board to Robert Towery. He would now like to address the board.
Thank you. Mr. Towery, go ahead.
Good morning. I would like to thank the board for this opportunity and for consideration of my case. First and foremost, I'd like to apologize to Mark's family. I have the deepest regrets for what I did. And I'm truly sorry for their loss, for what I did to them. I truly wish with my heart that I had not taken Mark's life. And it's a terrible thing that I did, and it should never have happened. He didn't deserve it, and nor did his family deserve what I did to them. I can only pray that they will find peace, and that someday they'll be able to forgive me. I would like to apologize to my family for being such a train wreck for so many years. Excuse me.
You can remain seated if you wish to, Mr. Taylor. You don't have to stand. We respect.
I'm sorry that my actions of 20 years ago is bringing back all the pain of our past. Thank you for always standing by me and for going through this with me. I have spent the last 20 years trying to, thinking about what I did and
Thank you, Mama.
what I was doing with my life. Things that they don't make any sense to me today. I can't make sense of it. I cannot for the life of me understand it. And it was just one terrible mistake after another. It ended in taking Mark's life. And I wish I could change it. I can't take it back. All I can do is try to ensure that others don't make the same mistakes that I made.
I have a question, Mr. Towery, if I may.
Yes, sir.
Under what circumstances did you know Mr. Jones?
I met Mr. Jones through one of the young men that used to hang around my house, would help around the shop and stuff. I was told it was his grandfather.
You were told that Mr. Jones was his grandfather?
Yes, sir.
Okay, and then what else did you find out about Mr. Jones at that point?
Well, at that point, when I met him, he ended up actually being a client of my shop. He helped me with the contracts for my shop.
What was your shop and business at that time?
I owned a mobile auto mechanic service.
Mobile auto mechanic? Okay.
Yes, sir.
And then you obviously, because he assisted you, then you began to know more about him. Is that accurate?
Yes, sir.
Okay.
Thank you, Alex. Appreciate it.
And how long after you met Mr. Jones did the suggestion, ideal come up in your mind to rob him?
I'm not sure on timelines. I have a hard time remembering spatial timelines, but I'd say about a year.
Okay. And was it that you realized that he was in possession of some type of property or something that might be of value?
At the time that when Randy and I decided to rob Mark Jones, it was a choice that we made because I knew he had money in that house. It was a very nice house, and he had money at hand, and I was told he had a safe there.
Okay. And when the initial plan came, did you plan to take his life?
I think that decision was made in an instant, in that all I saw was a threat. I didn't want to be caught. I wanted to get the money and get out of town. And that's why I took his life.
Robert,
Yes, sir.
Did you understand the question? I think the question was, when you planned the robbery, did you plan to kill?
Yeah, thank you, Mr. Bates. In other words, when the plan was hatched to, okay, we're going to rob him, was taking his life part of that plan?
I think it was a possibility. I think it was considered.
Was it talked about between you and your co-defendant? The
Yes.
fact that
Yes, it was.
you might need to take his life in that process?
Yes, sir.
Okay, and your co-defendant was aware of that as well?
Yes, sir.
Okay, all right. Thank you. Mrs. Wilkins?
Well, maybe I should let him proceed.
Okay. Okay, thank you. Continue on, sir.
If this board grants my request for clemency, giving me a sentence of life without parole, I will do my best to pay for what I've done by continuing to speak about others or to others about the dangers and the life-destroying aspects of drugs. I will continue to be the best role model that I can be for my nephew, my kids, my nieces. Which brings me to my nephews and my nieces and my kids. And I'm sorry I wasn't a better man, better uncle, better father. I hope you will always remember what I've tried to teach you. Know that I'm very proud of you and that I love you so much. Again, thank you for this opportunity and for considering my case.
Thank you, sir. Mrs. Wilkins?
Mr. Chairman, I have the letter that Mr. Towery read.
Oh, okay, thank you.
And Mr. Towery, you have admitted, Mr. Belcher, that you and Mr. Barker had discussed the possibility of murdering Mr. Jones, correct?
Yes, ma'am.
And how were you going to do that? What options did you discuss then?
We didn't discuss any options. I mean, we both carried guns. We had ample means, it was not discussed, just the possibility.
But there was only one gun brought to the murder, is that correct?
No, ma'am.
Or to the house?
No, ma'am. I had my gun and Randy had his. And then he ended up with my gun also.
And it was on him in the house,
Yes, ma'am.
as well as your gun?
Yes, ma'am.
And you had them loaded?
Yes, ma'am.
And as you failed in your attempt to be able to inject Mr. Jones with a battery acid or whatever substance that you had him convinced would put him to sleep, and you then used the ties around his neck, is there a reason you didn't take out the gun and shoot him?
The
I
gun
mean,
would,
obviously he suffered.
I didn't want to use the gun. A .357 is very loud. I didn't want to draw attention to the house. I just didn't think that would have been the thing to do at the time.
And what type of gun did Mr. Barker have? Could you not have used his gun?
He had a 9mm, I believe it was 9mm or 38. I'm not positive. I believe it was a 9mm though. And it's been basically as loud.
And truly, what was the purpose of the syringe all along when you took it?
I have no idea about the syringe. I don't remember using a syringe. I don't remember having the syringe. It's not the kind of syringe that I had, but I take responsibility for what happened to Mark. What Randy did, what I did, that's on me because I could have stopped it.
And then to pursue your relationship with Mr. Jones a bit further, he certainly befriended you and helped you.
Absolutely.
Was any of it through monetary means?
Yes, ma'am. As a matter of fact, he had lent me money before. He had, like I said, he helped me with my business and I worked on his cars and was paid for it. He gave me generous tips. He was actually quite nice to me.
And obviously must have thought a lot about you. It was at, what, about 6:30 at night when you approached his house?
9 o'clock.
9 o'clock at night, I'm sorry. And he let you in, and obviously he did feel that you were a friend and somebody he could trust,
Yes, ma'am.
and had no problem with letting you into his home on that day.
Yes, ma'am.
Obviously he did feel.
Hey,
And how much
Keeps,
money
great
did
to
he
see
loan
you.
you over a period of time?
I think there was 2 occasions, I would say between the two, about $1,500.
And you did repay it.
Oh, yes, ma'am.
And then may I ask, were you using drugs at the level of 3.5 to 7 grams a day during the time you were operating the business? And that he knew you in that year, and I'm assuming this is about 1 year prior to the time of the murder, that he befriended you and you became friends with him and he helped you. Were you using meth at that rate for that entire year?
No, ma'am. It spiraled downward very quickly. I was using it when I first met him and stuff like that, but it wasn't at that level. No.
Thank you.
Yes, ma'am.
Thank you. Any other? Just Kirschbaum.
Sir,
Yes, ma'am.
prior to this offense, you had just previously committed another offense?
Yes, ma'am.
Tell me about that.
It was a spur of the, I can't even explain how stupid it was, because my girlfriend and I pulled into the bar and she went in and used the restroom. And when she came out, I said, it looks really like there's nobody here. And she said, there's only like 4 people in there. And inexplicably, I went and robbed them. I don't even have an idea of why. I just did.
Did that not jolt you or wake you up when that happened with what you did, because you got caught, right?
Yes, ma'am.
So what was transpiring in your mind after just having committed that offense? The fact that you could have almost killed someone doing that.
I can't even explain my state of mind. It doesn't make any sense to me now in looking back on it, because I did things that made no sense. Everything around me was a threat. Everything was I don't know how to explain it. I'm sorry. I don't know how to explain the state of mind. It's something that you just do. You don't think. You don't consider. You just react.
Okay, thank you.
All right, thank you. Thank you very much. Mr. Lasone.
Yes,
Yeah, I
sir.
have a few questions, Mr. Towery. You were in prison here in Arizona from what, 84 to 90 originally?
89, yes, sir.
And then you were paroled and then you were revoked.
Yes, sir.
And what did you do to lead to that revocation?
I was revoked when my parole officer showed up at my house and he found a shotgun at the house. So I was revoked for that.
For prohibited possessor kind of thing?
Yes, sir.
Were you using when you were in, where were you in Hyman? Tucson?
No, sir. I was in Perryville.
Perryville?
I didn't use drugs very much in prison at all. And really, the only thing I would smoke pot every once in a while. But I never had a dirty UA. I stayed away from everything else. I actually spent most of my time on the weight pile and working.
So then you go back in for possessing a shotgun.
Yes, sir.
Were you committing any other crimes during that stretch,
No, sir.
your first parole?
No,
And
sir.
then how long were you in before you were again paroled?
Approximately 3 months.
3 months and you were paroled out again.
Yes, sir.
Uh,
It was considered a minor violation because the shotgun wasn't mine. It was one of the other people that lived at the house.
There was some, you were asked about the hypodermic, and which I guess was a veterinarian type device rather than a human hypodermic. And you said you didn't really remember much of anything about it. There's something in the record about that Barker says that he saw you I think the night before, under the hood of a car, apparently, and what he described as what looked like you're attempting to take acid out of a battery. Do you remember that?
I remember it from the record, yes, sir.
And you don't remember doing it, though?
No, sir.
Okay.
Well, I know that wouldn't be the case
Why not?
because I'm a mechanic. There's no acid inside of a battery. I'm a licensed mechanic.
Right, I understand.
There's no acid in a battery.
When people refer to the term battery acid, what are we talking about?
The corrosion that happens in oxidation on top of the terminal.
That gunk that shows up?
Yes, sir.
I thought there was an acidic reaction that caused the generation of electricity inside a battery. Am I wrong?
No, electrolysis.
Electrolysis?
Electrolysis, thank you, sir. But there's no acid inside of a battery,
Okay.
just water.
And some kind of something for water to react with.
Well, the plates.
Plates, yeah. But anyway, you don't remember trying to extract any fluid, whether it's acid or
No, sir.
base or something? Okay.
No, sir.
And then Barker testified that there were really two strangulations of Mr. Jones,
Yes.
both with the same devices that had arrived at Jones's house inside your briefcase. Is that correct?
Yes, sir.
And what were they? What were those? Did you loop them together into a noose?
They were basically wire ties, heavy duty wire ties. Something like you'd see flex cuffs that the officers would use, but it was for bundling large bundles of wire.
Were they something you'd use in your business?
Yes, sir.
The auto repair business?
Yes, sir.
Okay. And you joined at least two of them together, maybe more.
No, sir.
No, just one was big enough.
Yes, sir.
Okay, and so you twisted it to work on his breathing without your having to hold it manually. Is that correct?
Well, it's a self-locking
Self-locking.
device.
Okay.
And once you pull it, it's locked.
Okay.
You have to.
And so you did that on him the first time.
I only remember one time. I understand that there was two times, but I only remember once. Everything seemed so quick. To me, we were in the house for like less than 45 minutes, but by the record and by all the testimony, it was much longer than that. But I don't have that same memory of the time.
What was Jones's reaction? From what the limited transcript that I've seen, I didn't get a good feel for what Jones's reaction was when after you took him to the bathroom.
Yes, sir.
And seemed to be gracious to him in that respect.
Yes, sir.
His hands are cuffed behind his back with
Handcuffs,
Barker's handcuffs.
Yes, sir.
What was his reaction when all of a sudden it changes from apparently I'd rather you knock me out with some kind of hypodermic, which apparently you don't remember,
No, sir.
to this threat to his life? I mean, what was his? Did he say anything? Did he ever ask you why you were doing this to him, since he was a friend?
Yes, sir. He did ask. This was prior to even going into the bathroom. He
Well,
asked me
okay,
why I
and he
was
said,
doing
yeah.
this.
Well,
And I told him I needed to get out of town. I needed the money to get out of town. And I apologized to him that I just had to go. And what my recollection, when we left the bathroom and then took him into the bedroom, there was no discussion about anything else. The ties were actually to be used on his wrist so that Randy could recover his handcuffs. But instead of putting them on his wrist, I put them over his head from behind and pulled it tight.
so it may well be that by the time he realized what was happening, he couldn't talk.
Correct.
Okay.
I do have questions.
Yes, Ms. Stenson.
Yes, ma'am.
Mr. Towery, when you were just answering Mr. Lasota's question, when you were telling Mr. Jones that you had to get out of town, did you ask him for money at that point? Or did he offer?
He did not offer, but I asked him where the money was. I asked him where his safe was. But in the context of the robbery, it wasn't like asking him for a loan. I was asking in the context of taking it from him.
And that memory seems very clear,
Yes, ma'am.
but yet I don't know how long, you say, according to the trial and everything, that it was longer than you think it was, but how is it that you became unclear in your memory from the time you taking him to the bathroom to the time that you inject him with the substance?
I don't ever remember injecting him. It makes no sense to me whatsoever. The type of needle used, everything about it doesn't make any sense. But at the same time, that doesn't matter. I'm responsible for what happened.
Do you have a theory of something else happening? How someone else injecting him using that syringe? Do you have a theory?
Thank you, Grammatic.
Yourself?
I can only say that while I was searching the house for what they had told me was almost 2 hours, Randy was holding the gun on Mark. I was not in that room. I don't know, but I know I don't remember doing anything to him with the needle. I would not try to inject somebody way up here on the bicep with a needle. It doesn't make sense to me. It wouldn't be what I would do.
It's almost as if you're implying that Randy had the syringe. Is that so, or is that?
I don't know. I don't know.
Okay. All right, thank you.
Yes, ma'am.
Yes, Mrs. Wilkins.
Well, my follow-up to what Ms. Stinson's line of questioning is, I do realize that you were in another part of the house looking for the money, the safe, and whatever items you wanted to take, and that Randy was in the bedroom with the gun on Mr. Jones.
No, ma'am.
No. He was in the other part of the house,
Yes, ma'am.
the living room at that point. Now, when you took him back to the bedroom, you were with him though constantly.
Yes, ma'am.
You would have noticed if he'd had any.
Thank you, Grace. That is super generous of you.
I didn't even look.
Between the living room and the bedroom, you didn't notice if there had been, because supposedly you tried to inject him in his feet, so his socks would have been off,
I don't even know anything.
as well as both arms, is reported, I believe, in testimony provided by Randy.
I don't even remember that in the
And he
test.
had his socks on when he went to the bedroom,
Yes, ma'am.
because then Randy actually removed his. It's kind of unclear. I think
Well,
he was going to remove them, but Randy, I think, ended up removing Mr. Jones's socks.
I think Mr. Jones took off his shoes, but I could be wrong. I mean, Randy might have done it. I'm not sure.
All right. Thank you.
I don't think, excuse me, ma'am. I
Thank you, Pam.
don't think Randy, in the bedroom, I don't think Randy ever went near Mark. I don't remember him ever going near him. He was at the foot of the bed pretty much the whole time.
The whole time?
Yes, ma'am.
Because you really never left the bedroom either, though.
No, ma'am.
Thank you.
First one, you have a question?
Yes, Mr. Towery,
Yes, ma'am.
in the information we had, it states that the syringe was thrown away into some bushes. Who threw the syringe away?
I only know what they said.
Hi, Jim. We're live here. This, of course, took place many, many years ago, but we are live.
They said in the record. Randy said that he threw the syringe into the bushes. I don't know.
So you don't remember any part of that at all?
No, ma'am.
Nothing to do with the syringe?
No, ma'am. I have seen it. I know Randy had one, but I mean, it was completely useless to me.
So you do recall there was a syringe?
Randy had the syringe
Randy
at
had
the
it.
house, his house. He owned it. It was his.
Oh, I see, okay. And hearing Mr. Jones was basically a kind individual to you. He
Yes,
was
ma'am.
like a friend trying to help you. Why did you kill him? Why not just rob him?
I don't know. I don't know why I did it.
And you have no idea.
I only thought I had to get away. I had to get away. And I wish I wouldn't have done it.
And I have one last
Yes.
question for you. You know, your story is very similar to a lot of individuals we see in your situation. They've come from horrendous backgrounds. They're drug addicts and commit a crime that they terribly regret years later. They've done well in prison. Seem like a very nice person. But the issue is the crime. Why should we look at you any different than any of the other folks in the same situation?
All I know is that I've done my best to change my life. 20 years I've spent getting it together and trying to be a good dad and good uncle. That's all I can do. It's the only thing I can do. And try to speak about the life-destroying aspects of drugs. As I don't know why I would be considered any different than anybody else. I'm nothing special.
All right,
Josh,
thank
I
you.
have another question.
Yeah, Mr. Russo.
Mr. Towery, do you remember discussing with Mr. Jones when the next people would be coming to the house, like cleaning people or friends or family?
Yes,
And he basically said that he didn't expect people for several days. Is that right?
yes, sir.
Okay. Why did you ask him that?
I want to say that I didn't want Mark to be tied up for a long time, but I don't know. I can't sit here and say that I was trying to be merciful about it or anything else. I was carrying on conversations with Mark that were inconsequential, that really had no meaning, just for the purpose of getting through the event, the night.
Like we call making small talk.
Yes, sir.
Thank you.
Thank you.
May I have
Thank
a
you.
moment, Mr.
Yes, sir.
Chairman?
Mr. Bates, if I can, if you want to, have a little bit of time with your client to talk with him, we can arrange that. Maybe we'll take a short break and then you can.
I think there might have been some confusion about the timeline on the armed robbery that happened first.
Okay.
The armed robbery happened, and then within a couple of weeks later, the murder happened. I wasn't arrested between the two.
Oh, so you had not been apprehended for the armed robbery?
No, sir.
Okay.
So you're still on parole?
Yes, sir.
Yeah.
There was no attempt to revoke your second parole at the time of the murder?
No, sir. It was, the two happened, and then I was arrested.
Do you feel that you might need some time to?
I think we're okay. We could
Okay. Okay.
discuss matters with Mr. Towery during the break.
Okay. All right.
Thank you.
All right. Thank you.
But do ask for a break if you
Sure.
think.
Sure.
And Mr. Towery, I think it might be appropriate at this time to introduce your visitors. You were making some statements and apologies to members of your family. Oh, okay. All right. Thank you. That's fine. Just disregard that.
Thank you, sir.
All right. Thank you.
Good morning, Mr. Chairman.
Good morning, sir.
Members of the board. My name is Pablo Stewart. I will be proceeding with a few questions from the attorney.
Dr. Stewart, I'd like to introduce your experience and background to the board so they have a better understanding of your history. Can you tell them a bit about your education and your work history?
First of all, I'm a psychiatrist.
If you could, speak up
I'm
just a
trouble
little.
hearing.
Right. There we go.
Never been accused of being soft-spoken before, so that's a little different. Yeah. I'm a psychiatrist. My educational background starts as an undergraduate. I attended the United States Naval Academy at Annapolis, graduating with a degree in chemistry. And after that time, I served 5 years in the United States Marine Corps as an infantry officer. Upon completion of my military service, I was accepted by the University of California in San Francisco School of Medicine, where I completed my degree, my medical doctorate degree in 1982. After that time, I stayed on at the University of California to complete my internal medicine internship and my psychiatric residency program, which I completed in 1986. Since that time, I have worked at the University of California, San Francisco, at different settings. I worked at the county hospital where I ran the inpatient forensic unit. And that we took care of the patients from the county hospital, from the county jail who needed inpatient psychiatric care. I also then took a transfer within the university and ran a drug and alcohol unit at the San Francisco Veterans Administration Hospital. And that hospital was, my unit was particularly tasked with dealing with what we call dual diagnosis patients. People very similar to, as I explained about Mr. Towery, who have a concurrent substance abuse problem that's coexistent with the mental health difficulties. During the course of my career, I've worked as a forensic consultant, and I currently continue to work as a forensic consultant. I've worked for federal courts in California, supervising the variety of consent decrees and court orders that mandate certain levels of psychiatric and medical care within the California Department of Corrections. I've worked for the Department of Health and Human Services. I've also done work for the U.S. Department of Justice as a juvenile medical and psychiatric consultant. And again, in that capacity, I've gone through different places in the country and monitored the agreements that different states have gotten into with the federal government for the provision of psychiatric care. That's sort of a highlight. And I don't wish to go over my whole CV here, but those are the things that I do. And I currently still work as a clinical professor of psychiatry at the University of California School of Medicine. And I also work as a forensic consultant.
Thank you.
Dr. Stewart, the board has your report, which is Exhibit 15 to our clemency petition. In your report, you've reached some conclusions, psychiatric conclusions about Robert. Can you describe to the board what you did to reach those conclusions?
In arriving at my opinions that you've seen here, that you can see in my report, I examined Mr. Towery on 3 different occasions. I saw him 3 times here at the Browning unit. Twice was through the plexiglass, and one time we had a 3-hour contact visit. I spent a total of 8 hours with him. In addition, I reviewed the materials that you could see I listed in my declaration as far as having to do with his trial, having to do with social history documents. And in addition, I also interviewed both of his sisters on the telephone.
After doing all of that, what conclusions did you reach about Robert?
The psychiatric conclusions that I reached after completing my evaluation were that at the time of the crime for which he was sentenced to death, he was suffering from post-traumatic stress disorder, major depressive disorder, and substance abuse disorder.
I'd like to walk the board through your findings, and I'd like to start with PTSD, post-traumatic stress disorder, because I think a lot of us have some familiarity with PTSD, at least through television, where we see the stories about soldiers who return from battle and have flashbacks and are easily startled. Can you describe PTSD for the board in a little more detail?
There is sort of a Hollywood notion about PTSD. You know, a veteran's walking down the street and a motorcycle backfires and the person dives in, tries to dig a foxhole in the ground, and these sorts of things. And that certainly can occur. That's one example of PTSD, but that's sort of an extreme example. The majority of people who suffer from PTSD have been exposed to trauma during their childhood and adolescence, very similar to Mr. Towery. What the condition itself is a neuropsychiatric disorder. It's the only psychiatric condition that's defined by an external event or events. All the other psychiatric disorders are considered inherent biological conditions that happen, like schizophrenia or bipolar disorder, something like that. PTSD is very different in that it's defined by an external event. That's the first thing you have to establish the diagnosis is traumatic experience. And then, as it's been studied very well since the Vietnam War, that exposure to traumatic experiences then causes physiologic changes in a person's brain. It affects the way they perceive reality. It affects the way that they can plan and think about things. It affects their cognitions. So I call it a really severe neurocognitive disorder. And I would like the board to really appreciate the fact that a person suffering from PTSD doesn't think the same way as a person who doesn't suffer from PTSD. Their thinking is very, very impaired. That's the main thing I would hope that I could convey to you today.
You've also found that Robert suffered from major depressive disorder, I think since he was from a child. Can you explain to the board the differences between how depression manifests in a child versus an adult?
Well, if I can.
Oh, did I jump in too soon?
No. I want to get to that question, but I guess what I wanted to end this whole discussion on PTSD was that PTSD doesn't exist by itself. It is one of these conditions that is commonly associated with what they call comorbid psychiatric conditions. And there's I call it an unholy triad of conditions that exist in someone who have PTSD. You have post-traumatic stress disorder. 88% of the people who suffer from post-traumatic stress disorder also suffer from major depressive disorder, which was my findings here with Mr. Towery. And that same group of people who are now suffering from PTSD and major depressive disorder also have a substance use disorder. And I'll explain a little further about how that's all interrelated. Now, the question that I was presented about how does depression present as a child and adolescent as opposed to an adult, you really look for these psychiatric disorders to have objective presentations. And so in a child, you see that in acting out behavior in school. You see that in poor academic performance. You see someone not be able to keep up to grade level, which all is the case here with Mr. Towery. That's how you see that as a child, as opposed to an adult who is able to express to you, I'm feeling sad, I'm feeling suicidal, I don't feel like getting out of bed, these sorts of things. Children and adolescents don't necessarily come forward with those symptoms.
We've heard, the board's heard Ms. Day talk about Robert's extensive meth use around the time of this offense. Can you explain to the board what that means from a clinical perspective?
From a clinical perspective, the amount of methamphetamine that has been documented that Mr. Towery was using at the time of this offense is a tremendous amount. And you see the numbers, there were 3.5 grams to 7 grams a day. And you wonder why those idiosyncratic numbers are what he reports using. And that is the 3.5 grams is 1/8 of an ounce, 7 grams is 1/4 of an ounce. And methamphetamine is also often sold in ounces or eighths of ounces or quarters of ounces. But this amount of drug use is tremendous. Methamphetamine is a psychostimulant that has a significant psychiatric sequelae associated with it, namely aggression, impulsivity, further impairing your cognitive functioning. At the level that Mr. Towery was using, it very likely causes delusional thinking, paranoia, as he's talked about this morning. And paranoia, is misperceiving your reality, thinking and really experiencing a threat when there's no threat there. I always remind people that if people are really out to get you, you're not paranoid. But if you're thinking that people are out to get you, when in fact there really aren't, or every little benign situation you find yourself in, you're feeling under threat, that's paranoia. That's associated with a degree of methamphetamine use that he was doing at the time of the crime.
Can you talk a little bit about how Robert's substance abuse played into or interacted with his PTSD and his major depressive disorder?
You had a very good presentation about the extent of his use and what Dr. Bayless had reported at the original trial. And the thing about Dr. Bayless is that he got it partially correct. He was unable to link it, and I believe because he didn't have the extensive interviews and ability to speak to people about Mr. Towery's background. But he wasn't able to link it to any what we call a pre-existing psychiatric disorder, because Mr. Towery's drug use doesn't exist in a vacuum. There are some people that use drugs and that's all they do. That's their problem. They use drugs. In Mr. Towery's case, he had, to my opinion, which I hold to a reasonable degree of medical certainty, that he was suffering from post-traumatic stress disorder and major depression. Those two conditions are the ones that are most likely to be what we call self-medicated. And self-medication carries a lot of meanings in the community. How I think of it, and the psychiatric community thinks of self-medication, is that a person has a psychiatric disorder, usually undiagnosed, as was the case with Mr. Towery. They find relief through the use of substances. He began drinking at 6 years old. I mean, that alone should have bells going off in psychiatrists and psychologists' minds when they were interviewing somebody like this, that there's something else going on. It is not usual for 6-year-olds to start drinking, even in the context in which Mr. Towery's drinking occurred. And then you go to the next time when he started smoking marijuana at the age of 11 and 12. Yeah, certainly some kids smoke marijuana at 11 and 12. I'm very aware of that. But also it was happening at times when his parents were divorced. And now he's living there with his mom, and whatever protection that he had from the person he knew as his father was no longer there from the abuse of his mom. And it makes perfect sense to me from a psychiatric standpoint that his marijuana use would pick up right then because of the fact that he's now experiencing this trauma. And then finally, when he starts using cocaine and methamphetamine during high school, as well as the other substances that you saw listed, he gives a very interesting response clinically. When I asked him, he says, well, what were the drugs doing for you? A typical response would be, oh, I got high, I was able to have sex, I was able to do this, I was up all night, et cetera, et cetera, et cetera. Okay, that doesn't really talk to us about self-medication. But Mr. Towery's response was that it made me feel. I started to experience emotions that I think other people experience, which isn't, I have to do further evaluation, but that is an answer that really implies that he's self-medicated. So he has this overwhelming self-medicative component to his substance use. So I would have you consider that he's not just a drug addict, but he's a person with severe pre-existing psychiatric disorder that because he wasn't offered formal treatment, he wasn't taken to a child psychiatrist or anything, and given treatment for his conditions, people find out how to take care of themselves. And that's what he did. And that's how I would have you think about his substance use.
At trial, the judge made the statement that Robert had voluntarily chose to live his life on meth, and I think that goes to what you're talking about right now. From a clinical perspective, do you think that the judge has accurately described Robert's substance abuse?
You know, again, I think the judge got it partially correct in that I'm not here to tell you that he had no participation in his drug use. Okay, there is a volitional component to drug use. There's no question about that. But what I think that statement implies to me is that the particular judge in the case wasn't presented information about the severity of his mental illness to put the drug use in a different context.
I think for the board's information, or maybe the ultimate question is, you know, what does this all mean? How did this impact Robert on the day that Mark Jones was killed?
Yes. Putting together this, hopefully this is consistent with what I've been telling you so far during this presentation. And I would like to start at the end of the story where the person has cognitive dysfunction. And that's the fancy psychiatric term for you're not thinking clearly. You know, I certainly was listening when the board was asking Mr. Towery, said, well, what was the deal? Why didn't you just shoot him? What was the deal with the syringe? Weren't you there getting battery acid? You know, why didn't you ask him where the money was? And the responses were, I don't know. I don't know what I was thinking. And that is absolutely consistent with a person who has cognitive dysfunction. They don't know what they're thinking. They're unable to appreciate what's going on around them in a way that all of us here today could appreciate the circumstances. Because we're thinking about this in a non-cognitively impaired way. So that's the end of the story. But we can go back, we can see where it all began. Trauma, which then resulted in post-traumatic stress disorder and major depression. He then finds a way to address some of his symptoms through self-medication with illicit substances. And then that further contributes to his cognitive dysfunction. So now we have three things that are impairing his ability to think clearly at the time of the crime.
All of the information that you've provided to the board through your report and here speaking with the board today, was this available back in 1991 at the time of Robert's trial?
Yes. You know, as a psychiatrist, and being asked to review cases like this, you know, I have strong reactions to the fact that the information that I'm talking with you about this morning is not stuff that was discovered last year or even, you know, during the 2000s. This stuff has been around. This is not new material. You know, we at the Veterans Administration hospital where I was working, you know, in the 80s, this was appreciated. People with PTSD self-medicate. And so this information was available to people at the time of his trial. But yet no one was able to put the different pieces together. And I don't know why. And I'm not blaming anybody. I'm just saying the net result was that no one was able to put this all together for anybody in a way that I'm hopefully expressing it to you today.
The board asked Robert why they should look at him any differently from the other people that come in front of this board and have committed crimes and appear to be changed people. Do you have, from your clinical perspective, do you have any information that you can offer the board to help them grapple with that question?
I think that, yes, I do. And I think that's an excellent question. Why should we think about you differently than someone else who comes here, been in prison for 20 years and appears to be reformed, just expresses remorse, et cetera, et cetera? Well, in Robert's case, he has all of these things that were happening to him through no fault of his own. He didn't choose to have a genetic predisposition for substance abuse because mom was an alcoholic. He didn't choose that. He didn't choose it wasn't his wishes to be sexually abused or to be beaten by his mom over an extended period of time, or having your mother arrest you when you go back in your house to take a shower. That was not anything that he was wanting to do. And it resulted in a situation that put him at extreme risk for continued substance use. And in the absence of formal psychiatric care, I think we see what the results was. I think I would have you think about it that way, that it is different. This is not the same as other cases where the person doesn't have that particular background and psychiatric disorders and clear pattern of self-medication of substances.
Is there anything else that I haven't covered that you want to share with the board about Robert?
I can go on this for a while, and I know I don't want to, but if there's anything that I would need further clarification, it'd be my pleasure to try to answer questions. Yes, ma'am.
Mrs. Kirschbaum.
Doctor, how do you diagnose PTSD?
You diagnose PTSD by a combination of things. You certainly listen to the person telling you their story, but oftentimes, because of the illness, because of one of the major features of the illness is avoidance of discussions about the trauma, that we try to establish the trauma by third-party sources.
Thank you, Mary.
Which was done in this case. But also during the course of the interviews, I'm observing, in this case, Mr. Towery, to see if he's presenting any behaviors that are consistent with PTSD, and he did. I won't bore you with going over my report here, but you'll see that I listed all the diagnostic criteria, and one of them is psychological distress and physiological reactivity when you're sort of forced to deal with some of the traumatic experiences. And that clearly was happening during the course of our interviews. The hyperarousal, the exaggerated startle response, these are things he demonstrated to me. But also the last thing, because I don't want to just keep going on about this, is you listen to the story. And if you listen to Robert's story, you hear the story of PTSD in there. And then now I go back in to try to confirm it by looking for symptoms, getting third-party collaboration, etc. That's how you do it.
And so you're saying by the fact that he was using drugs, that he was self-medicating to have feelings that others didn't have. And I guess my question to you is, so we have someone with PTSD who had depression and all. So how does he medicate himself now? Is he on medication, psychotropic drugs at this time, or is he just functioning just fine?
Well, I don't, that's a very good question. I don't think he's functioning just fine, first of all. And he has been on antidepressant medication with the Arizona Department of Corrections. But I just want to clarify something that you were saying. I don't mean to say just because he was using drugs, he was self-medicating. But in listening to his particular story about his history of drug use, it's very suggestive of self-medication. 5-year-old, 6, 7-year-old drinking alcohol, 11-year-old marijuana. Then you sort of compare that to events that were happening in his life at the time. That looks like self-medication, further confirmation. And he has been treated. And also, he's away from drugs now. He's in a situation where he's no longer continuing to be abused by his mother. So things are not well for him, but it's sad to say that this has been a stable period for him. I think it's evidenced by his behavior.
Thank you.
All right, thank you, sir. Thank you. Okay, yeah. We're going to take about maybe a 10, 15-minute break too.
So we have part 2 that we're going to kick in here. We don't need to take the full break, but I do want to just share some of my thoughts on this for about a minute. And also thank you all for joining the 20,000 subscriber live chat. So one thing I thought was interesting that the therapist was saying that, in his words, I don't know what I was thinking. And he's saying that is cognitive dysfunction. But what was brought up very early on by the prosecutors, and we're going to hear soon a lot of that. And then at the end of this hearing, we'll go over some very interesting pieces of information, details on the crime. We'll go over his diary, the last basically 30 days. But how can you say that you don't know what you're thinking when you made the conscious decision not to use a weapon because it would have been too loud and it would have drawn attention to your robbery? So instead, you suffocate, you choke him to death. That's not having cognitive dysfunction. That's not saying, I don't know what's going on. So it seems very easily debunked. I've never been a fan of having these like specialist doctors come in and try to twist a story to saying that, well, he was a drug addict, but then calling it a self-medication. Since when is taking incredible amounts of meth every day self-medication? That's not self-medication, in my opinion. But anyways, that's just my opinion. I'm not saying whether or not he should get the needle, but certainly the argument that they're making doesn't, frankly, I think they can do a better job. But again, that's just my opinion. But now let's jump in.
All right, it's 10:15, and we are resuming the clemency hearing on behalf of Mr. Robert Towery, DLC number 51550. And Ms. Dave, would you like to continue?
Yes, thank you, Chairman Belcher. In Mr. Towery's case, the Arizona courts refused to consider evidence that he was physically and emotionally abused by his mother as evidence of mitigation of his death sentence because he did not show that this evidence was causally linked to the crime, which was the law in Arizona at the time. Under the law of the United States Supreme Court at that same time, it was clear that evidence of a difficult family background and abuse is to be considered relevant mitigating evidence, and that the sentencing body, whether it's a jury or a judge, may not be prevented as a matter of law from considering and giving effect to this evidence. Because of this, Robert's attorney during direct appeal raised this as a claim. Nonetheless, the Arizona Supreme Courts applied the Arizona law again and upheld the sentencing decision. Because the state courts were given the first opportunity to correct this error, this claim could have properly been raised in Robert's federal habeas petition. This would have allowed a federal court to correct the error involving federal law. Despite this, Robert's federal habeas attorney did not raise this claim in his federal habeas petition. In 2004, while Robert's case was still pending in federal court, the United States Supreme Court clarified that the type of causal nexus test that the Arizona courts used in Robert's case was unconstitutional and had always been unconstitutional. Because it was not a new law, Robert could have benefited from this clarification. However, his federal habeas attorney failed to file an amended petition raising the claim in light of this recent case. Federal law at that time would have allowed this amendment, but for no reason at all, his federal habeas attorney failed to do this. Robert is now prevented from raising this claim because it's been waived. It's clear from the record in the case that the sentencing judge clearly applied this causal nexus test. At his sentencing, his judge stated that a difficult family background in and of itself is not a mitigating circumstance, and that a difficult family background is only relevant if the defendant shows that something in his background affected his behavior at the time of the crime. The Arizona Supreme Court likewise noted that because Towery failed to connect his family background to the criminal conduct, he was not entitled to relief. This is not a situation where we are asking the board to ignore the law or second guess the courts. We're asking the board to apply the law that the Arizona courts were required to apply and that Robert could have benefited from had it not been that his federal habeas attorney failed to raise this. This board can correct this error now, which would have allowed Robert to have a new sentencing proceeding before a jury rather than a judge who would now apply the correct law. We believe this error can be corrected by the board commuting Robert's sentence to life without the possibility of parole.
All right.
My name is Natasha Merle. I'm with the Federal Public Defenders.
Good morning.
If this board recommends commutation for Robert, it can be confident that he will serve a life sentence without incident. It is evident from his prison record of the last 20 years that sober and in a structured environment, Robert does not pose a threat to staff or other prisoners. As you saw in his records, only a year and a half after Robert began his sentence, he was already at the lowest risk score possible. This came after the Institutional Classification Committee twice recommended that his risk score be decreased in 1993. Robert was able to maintain these low risk scores for the last 2 decades because he has received only 7 write-ups during that time. And none of these 7 disciplinaries involved acts of violence. In fact, Robert has not had a citation of any kind in the last 8 years since 2004. One thing emerges indisputable from Robert's record: Robert does not pose a threat of violence. The death of Mr. Jones is indisputably tragic. As this board is aware, however, most defendants convicted of murder are not executed. The death penalty is reserved for the worst of the worst. This is a felony murder case. As the jury said, 0 of us find the state proved premeditated murder, 12 of us find the state proved felony murder. The jury did not find that there was any premeditation in Mr. Jones's death. This case is clearly not the worst of the worst. Defendants in many crimes with far more disturbing facts than those presented here have received life sentences. We presented some of those cases to you in the petition. We brought the case of Frank Lewis to your attention. Lewis was convicted by a jury of 2 counts of first-degree murder and 2 counts of kidnapping. Lewis started a fight with 2 men in a bar. He and 2 companions beat up the 2 men, broke a beer bottle over one of their heads, and then tied them up with a rope. He then dragged them outside and threw them in the back of a pickup truck, where he drove them to a secluded area, an isolated area, where he again beat them with a tire iron, stabbed them, and cut their throat. When they were dead, him and his companion threw them into an irrigation canal. Lewis was sentenced to consecutive terms of life imprisonment. I'd like to point out 2 other cases which were not included in our petition with facts more heinous than the ones we have here, and the defendant also received life sentences. The first is that of Gary Skaggs. Skaggs was convicted by a jury of 2 counts of first-degree murder. Skaggs killed 2 people with a machete. The couple sustained chop-type injuries, including lacerations and bone fractures. Their bodies were discovered when their baby's cries alerted a friend to the crime. Skaggs was sentenced to consecutive life term of imprisonment. The next is that of William Bates Wilcox. Wilcox was convicted by a jury of first-degree murder in connection with the kidnapping, torture, robbery, and murder of an Arizona man. Wilcox and an accomplice broke into the victim's home, while he was watching television with his dog. He stuck a gun in the victim's face, knocked him to the ground, hitting him. He hit him over the head, dropped the television set on him, then bound him behind his back with his hands with a cord, and placed a dresser on top of him so that he couldn't move while he robbed his home. When he was finished robbing his home, Wilcox then set fire to the victim and his home. He was convicted of first-degree murder and sentenced to life imprisonment. As this board is aware from the many cases it sees in parole hearings, defendants convicted of more heinous crimes than the one for which Robert is facing execution appear before this parole board for determination if they should be released from prison. Robert is facing execution in less than a week. He asks only that his life be spared. I'd like to turn to the state's star witness against Robert, Randy Barker. At one time, Barker was in the same position as Robert Towery. The county prosecutor had gotten an indictment against Randy, charging him with the robbery and murder of Mark Jones. The prosecutor was going to seek the death penalty against him. And then one day, Barker catches a big break. He cuts the deal. The same prosecutor who presumably had in good faith obtained an indictment against Barker, who presumably in good faith thought Barker was deserving of the death penalty, cut a deal with him. Though Barker lied to the police on numerous occasions and admitted to police that he was a professional liar, even stating, "I'm usually able to lie pretty good," a deal was made that made Barker a free man in 10 years. Barker was an integral part in the events leading up to Mr. Jones's death. The deal that was cut with Barker resulted in a sentence so disproportionate that one partner was released after 10 years and is freed today, and the other, Robert, faces execution. As stated in his pre-sentence report, Barker's participation was far from minor. Let's go through Barker's involvement in the crime and how he was a key player. In preparation for going to Mr. Jones's home, Barker picks out clothes from his personal wardrobe that he and Robert should wear to the robbery. Barker brings his gloves. Barker brings his handcuffs. Barker drives himself and Robert in his car to the Denny's restaurant, where they will hire a cab. Barker pays for that cab ride to Mr. Jones's street. And once they are at Mr. Jones's home, Barker distracts Mr. Jones by pretending to make a phone call. At this point, Robert tells Mr. Jones that they're going to rob him, and Barker proceeds to handcuff Mr. Jones with his handcuffs. Barker, with his gun in hand, leads Mr. Jones to his study. Barker holds Mr. Jones at gunpoint for 2 hours while Robert searches Mr. Jones' home for property and cash. It's clear that Barker had to do this to prevent Mr. Jones from escaping or making any calls for help, as Robert was in other areas, other rooms of the house. Once Robert is finished searching the home for cash and property, Barker helps move Mr. Jones into the bedroom. And then Barker remains in the bedroom, still in possession of the gun, and again keeps an eye on Mr. Jones while Robert again leaves the room. Barker stands only 4 or 5 feet from Robert when he begins choking Mr. Jones. After Mr. Jones is dead, Barker helps load a large TV into Mr. Jones's car, the car that Barker intends to steal until the alarm sounds and he gets in the car with Robert. Barker helps dispose of Mr. Jones's car. Barker splits the money obtained from Mr. Jones with Robert. and Barker disposes of the majority of Mr. Jones's property, making gifts of it to his family, his girlfriend's family, and a good friend. And then Barker covers his hide by lying to the police on at least 2 occasions. Despite Barker's integral involvement, the county attorney chose to cut a deal with Barker to beef up their circumstantial case.
What she's referring to right now is his co-defendant. So his co-defendant, believe it or not, and this is what she's about to bring up, only received a 10-year sentence. So in my opinion, she has a point, although you can just argue that the DA should never have given his co-defendant a 10-year sentence. But that's the point she's making now.
Case against Robert. Given Barker's involvement prior to, during, and after, under Arizona's felony murder law, Barker is equally culpable for Mr. Jones's murder. The disparity in the sentences of Robert and Barker is unfair. It is unjust. And the board has the power to remedy this disparity by recommending a sentence of life without the possibility of parole for Robert. On that point, I would like to remind the board that the United States Supreme Court has held that the method by which Robert was sentenced to death is unconstitutional. There is no question about that. Robert was entitled to have a jury of his peers decide whether his crime was one of the very few for which the government may put a citizen to death. Robert didn't get to have a jury of 12 people rather than one judge determine his fate. Not because he wasn't entitled to jury sentencing, not because it wouldn't have made a difference in his crime, in his case, but simply because of when he committed his crime. With that in mind, we are going to play a clip of the jury foreperson in Robert's 1992 trial, Colleen Butler. Though she was denied the chance to sentence Robert in 1992, she would tell you that she would have never sentenced him to death. As the board knows, it only takes one.
My name is Colleen Butler. Colleen, and did you have an opportunity to serve as a juror on a case in Maricopa County about 20 years ago? Yes, I did. Do you remember the name of that case or the name of the defendant? Robert Towery. And you were the jury foreperson, is that correct? Correct. Do you remember how you were selected to be the jury foreperson? Received jury duty went. It was an all-day process. We sat as they asked questions. I sat right behind the defendant. I remember that because I was watching him take notes as different people were questioned about what they did and their jobs. And I don't remember all the questions now, but I do remember when they came to me and asked me what I did. I worked for the Arizona Department of Public Safety at the time as a police dispatcher with Highway Patrol. And when I stated that, I saw the defendant cross my name out and write cop. So what do you recall about the case? I remember that Robert and an accomplice were accused of going to a home in Paradise Valley where an older man who I believe was known by Robert lived, and I believe in a wealthy area in Paradise Valley, and they went with the intention of robbing him. So do you recall the jurors discussing Robert's involvement in the crime in total? I mean, do you remember any discussions about that? And what, if any, conclusions the juror reached about who did what, so to speak? I remember there being some confusion as to who might have done what, that there was some thought was raised that this co-defendant was offered a deal, and so to not be executed and to be able to serve 10 years, he didn't have to say anything, and so it was not necessarily a credible witness. Having sat as a juror and listening to the co-defendant, Mr. Barker, do you have any thoughts about Mr. Barker's sentence or the disparity between the two sentences? I have very strong feelings about that. It greatly distresses me to think that he could serve 10 years and be out while his equal partner is about to be executed. That's such a disparagement. I don't understand. It's not like a difference between 10 years and 20 years or life and 20 years or life without the possibility of parole. It's 10 years and you're living a normal life now and execution for the same crime.
We talked a little bit about the mitigation that our office has been able to develop about Robert, his childhood, his adolescence, drug use, things along those lines. And we've shared some of that information with you. Had you had an opportunity as a juror to hear that, and had you had an opportunity as a juror to weigh in on what you thought the sentence would be, would that mitigation have made a difference to you in that decision?
It would have made a huge difference to know the details of Robert's life, to the mitigation, to understand his drug use, because especially now there's so much information today about medication that people are on, even prescribed medication by doctors. So of course the doctor will testify as to how that can affect your thinking and your behavior. And of course self-medication is the same thing. You are chemically altering your mind and you're not functioning or thinking rationally like somebody would who's not on. That would be a huge important factor, I believe, in would have made a big difference, huge difference. And I do understand that today the jurors would have the opportunity to hear that, and the jurors would have the opportunity to be part of the sentencing process, which I was very surprised and concerned and bothered to think that a single man or woman, a single human being, a judge, could make that decision themselves without any. I mean, the jury of peers is what it seems like, a group of people agreeing on something, weighing all their backgrounds and all their feelings and and the evidence and all of it together is much more likely to come to the right decision than a single human being. I don't believe that two people jointly committing the very same act, one should get 10 years and one should be given the death penalty. I believe the death penalty is for people who are the worst of the worst human beings. This man does not deserve the death penalty. And I hope that today they will apply it. If today this case was tried and I would have been part of that sentencing, I would have absolutely said no way. And I'm hoping that they'll go back and apply like they do when the new rules come in and new information, and they'll apply them to old cases. I hope the Clemency Board will take into consideration that this wouldn't happen if it happened today. This man would not have been sentenced to death if it happened today.
And this concludes our presentation at this time.
Thank you, ma'am.
Thank you.
I believe next we'll hear from Mr. Martinez from the Maricopa County Attorney's Office. After which, if there are any other individuals that wish to address the board regarding this matter, everyone will be given an opportunity to do that. Mr. Martinez.
Anyone recognize this man? If you don't recognize his face, you might recognize his voice. He was the DA who prosecuted Jodi Arias. So let's jump in.
Good morning. One of the things that is striking when you get to this point in the proceedings is that it seems that things are turned upside down. It seems that left is now right and up is now down. Because in this presentation, we heard nary a word, rarely a word about the murder in Mark Jones and how horrible it was. All we heard about was this individual, Robert Towery, and he was cloaked, if you will, in the garb of a victim. This is this individual that committed this crime, but now he's cloaked, as I said, as a victim. there was a mental health expert, a psychiatrist from California, who testified to you. And he said to you, well, you know, his cognitive, and I want to get the word correct so that we know what we're talking about. He was suffering from a cognitive dysfunction at the time of the killing. Of course, this expert wasn't there, or else we'd ask him why he didn't stop it. But he's saying that he wasn't thinking clearly. Wasn't thinking clearly at the time of the killing. But we know, again, that's probably a falsehood, that opinion. And the reason that I can say that with such strength and conviction before you is because the defendant himself, when he was being questioned by you, I don't know which one of you it was and what the question was, but his answer was, when he was asked about the guns, what kind of guns were there? And he mentioned that there were two types of guns. And then he said, and he was asked, which is something that was asked by the judge, why didn't you just shoot him? If you were going to kill him, why didn't you just shoot him? And remember, this is an individual that, according to their mental health expert, wasn't thinking clearly. And what did he say? Would have made too much noise. Does that sound to you like somebody wasn't thinking clearly at the time? Not once, but twice he told you, I didn't use my gun because it was too loud. We would have been found out. That's somebody who's thinking clearly. Well, why didn't you use Barker's gun? The guy that you are now pointing the finger at. Why didn't you use his gun? Well, I didn't use his gun because that would have been too loud too. Which brings us to the point that everything that has been presented to you, and I'll use their vernacular because that's the phrase that they really want you to use about this victim sitting here. And I'm talking about Mr. Towery because that's what they want you to believe, that he's really a victim. That everything that they told you is self-reported. Anywhere there, do you see a report about childhood abuse? See that anywhere there? If it was so heinous that they're talking about anal sex, they're talking about oral sex on a boy, they're talking about a situation involving a leg that he almost lost, almost, didn't lose it. We don't know how severe it was. Where are all those records? All you have is this individual's word, this individual who can't remember what happened there. And of course, their psychiatrist, who clearly is an advocate in this case, doesn't tell you about the concept of secondary gain, does he? And secondary gain is an issue that's out there for psychiatrists and psychologists. And that means that if you're interviewing somebody and they have something else to gain by self-reporting, something that is much more serious than it really was, or in fact ever existed, well, then you're going to make things up. And I point to the defendant's story about what happened to show you that he was making it up. And it's not something that I'm saying here without anything to buttress it or anything to support it. When he's asked about the murder, what does he tell you about that? You know, I was there for, according to him, it seemed like 45 minutes. Can't blame him for the time because he didn't have a watch, I'm sure. And it was like Disneyland for a thief, going through everything that he could possibly take, and there would be apparently no consequences. But what is happening during that time? Well, he remembers that. And in pointing the finger at the other individual, he remembers the syringe, because that's what Mr. Barker had. He remembers that. And he remembers where they went and what they did. But when it comes to his involvement, you know, he just can't remember it. Why not? Why is it that you have this selective memory? He has this selective memory because he is not being forthright with you. And that is something that you have to consider. Additionally, this doctor tells you that he has PTSD, post-traumatic stress disorder. And he says that, according to him, that's one of the only one that is, if you will, from an outside source. There has to be something outside that triggers it, implying that somehow something in that house triggered whatever happened. Well, if the inmate was going to go there, how did he know something was going to trigger him? How did he know he was going to have this post-traumatic stress disorder episode? And I asked that because he went well prepared, didn't he? He took a briefcase. There's no doubt that they took that. There's a syringe that he took. They planned it in advance. He even admitted to you today they planned or talked about killing. They planned to kill him. That's my statement to you today based on what I heard here. So they take zip ties that he has. Not only that, they take a gun. And who do they go after? Somebody that he knows. Some victim that he knows is not going to put up a fight. A 60-year-old elderly man. And people may chuckle and people may grin when you say that somebody's elderly at 68, but he was an old man. And you've seen the photographs that I provided to you. Look at the victim that they picked. So there is all of this planning that went ahead. Does that coincide? Or is there any indication that somehow PTSD there's going to be an event that would trigger that PTSD? That's a Johnny-come-lately kind of defense that they advance to you today and say it was available then. Well, the reason it wasn't presented then is the same reason it shouldn't be given any weight here, is because something that came later. It's a Johnny-come-lately kind of defense. And I say that too with great confidence because if you take a look at the armed robbery at the Jeff's Steakhouse in Mesa that the defendant talked to you about, I said, you know what? I don't even know why I did that. It was just, something that just happened. It wasn't anything that I planned. Really? Well, what about the backpack that he had with him with the gun in it? Is that something that just happened to be there? He walks around carrying a backpack with a gun? How about the zip ties that he used on that occasion? Just approximately a week before he did this, a sort of a trial run, if you will, to this murder. Did he tell you about those zip ties? No? And he walks around with those zip ties in that backpack? And he says, well, it's always pointing at somebody else. It's somebody else's fault. He's pointing the finger then at his girlfriend. The facts in that case indicate that he and the girlfriend cased the joint. And what happened is the girlfriend did go inside. She did go inside and claimed to want to use the bathroom, wanted to see how many people were there. And he had himself an accomplice there too. But if we're going to believe everything the defendant says, that's her fault too. It's not his fault because again, he's the victim here, right? That's who he is. But it was really a trial run. And was he also going to experience PTSD there? Is that why he brought the zip ties? Is that why he brought the gun? Is that why he brought the accomplice? It's almost the same set of facts as we have here. But he didn't tell you about those. Spur of the moment. He used the word spur. He didn't finish the whole sentence, but he did say it was spur and then went on to something else. There was nothing spur of the moment about that either. And the reason I mentioned that is because, again, you're being asked to make a decision really based on what this individual tells you. But look at not inconsistencies, it's much more than that. Dishonesty that is being presented to you so that you could feel sorry for him and decide this on sympathy without really looking at what happened to the victim. So what happened in that case with the zip ties? Well, this individual, after his girlfriend goes inside and tells him what's going on, how many people are in there, well, let's go ahead and rob it. She doesn't go in there with him, so she can't say that she was the primary actor, but he could certainly point a finger and say, well, it was sort of her idea. She went to the bathroom and it was spur of the moment. It wasn't spur of the moment. When he went inside, he got those zip ties and he began to tie those people up. And he tied them back to back and he tied them to a pole and was able to get away with the money. Approximately a week before this happened. And this is the individual that now wants you to believe that, well, when I went to Mark Jones's house, this elderly gentleman, when I went over there and I brought the zip ties, not my fault. It wasn't something that really we contemplated. It wasn't really planned. Nothing really wanted to go wrong. I brought the gun, but we talked about it, but we just brought the gun. Well, when you get inside the house, things begin to happen. And when things are negative or when things hurt him, that's when he forgets. That's when he doesn't remember. And why does he do that? Because he has a secondary gain. What else has he told you that perhaps is something you should consider? Well, he tells you, according to their psychologist, that he was using just a huge quantity of drugs. And it was referenced when Brad Bayless, the psychologist that testified at the proceedings with him. Where's there any proof of that? If he is so addled on methamphetamine that he can't remember the crime, How is it that today he can remember everything, but yet has these huge gaps that hurt him? The only thing that he remembers are things that are positive to him. Oh, I was using all these amounts of drugs. Oh, so much drugs that a normal person would be dead or something bad happened to him. Where is there any report? Where is there any toxicological report? Where is there anything from anybody that indicates he was? We don't even know that. It all comes from him. But that's what he wants you to believe. And then, of course, they buttress that or bootstrap the psychologist and say, you know, yeah, he was using drugs. The other thing that he talks to you about, and it's a horrible thing if it does happen, is that he was abused, that he was sexually abused.
Thank you, Jacob. Great seeing you again. That's very generous of you.
He had all these problems growing up. One cannot overemphasize the fact that there is not one strategy.
Thank you, Red. That's so generous of you. Thank you so much.
Of corroboration to that. There's no indication that anyone was prosecuted for that. And there's an indication that maybe it happened 20, 30 years ago or whenever it was. Well, as bad as he describes it, that is something that should have spiked someone. That is something that should have come out. There's no reason for an indication that actually happened, and there's no indication to show us that it actually is anything other than him, the defendant, coming to you and presenting something to you. So let's talk about the victim that he claims that he is, and let's talk about some of the things that he told you in their presentation. I touched on it now, but they tell you that in his childhood, there were all these things that happened to him, and that he began to use drugs, he began to drink, and he started to do a number of things. And just to shake the sympathy tree even a little further to see if maybe something falls to the ground and you pick it up and eat it as a fruit of this particular tree, they talk about him being a bedwetter. Well, where do we have any confirmation of that? And remember, this is an individual that has stood before you and has really told you a story, but he can't remember the syringe. He can remember, of course, that the other individual had the syringe, but he can't remember anything about him having the syringe. And while we're talking about the syringe and this issue of whether or not it had battery acid, I know that the board received a letter dated March 1st from the Federal Public Defender's Office, indicating that the prosecutor's use of that word, that statement is wrong and it contradicts a representation. It also indicated that both the trial court and the Arizona Supreme Court rejected the idea that the state had proven definitely that this individual injected somebody. And he was referring, and he gave the pages 2 and 4. And the statement from the state was the effect that the briefcase also contained gloves, plastic tie wraps, handcuffs, and a large veterinary syringe apparently filled with battery acid. And I point that out, not just to point the finger, but to show you to what lengths people will go. They criticize the state and they say that that is an error. Well, the problem with that is that the state took that from a guy by the name of Stanley Feldman, who happened to be the justice of the Arizona Supreme Court, who rendered the opinion. And that's verbatim from the opinion. So if the state is wrong, then perhaps Judge or Justice Feldman got it wrong too. And that's what they're telling you. You can't even believe the judges in this case. And so they turn and they criticize. They make it a personal sort of thing and say, well, the prosecutor got it wrong. Take a look at the written opinion. I cited it and I gave the actual citation, and you will see that that's verbatim what the justice wrote. I point that out to show you that they want you to believe not even what's in a written opinion. They want you to rewrite history. They want you to believe that what is up is now down and what is left is now right. And as part of that, they come to you with, yes, this childhood issue. They also come with this issue about crime and the drug addiction. That was considered by the Honorable Cheryl Hendricks at his trial. And she considered it. And so they want you to now reconsider it by putting another spin on it. And the spin now that they want on it is that since he's a victim, it's just not his fault. That's what they're telling you. It's just not his fault that this murder happened. Because remember, their expert said he wasn't thinking clearly. But that was considered by another judge. And the state submits to you that he is not a victim, and it was his fault. He also, in their rendition, they talk about the crime itself, and they talk about how what they want you to do is to commute the sentence to life in prison without the possibility of parole. I understand that this board has a wide range of powers, and I understand that the board can make various recommendations, but the life without parole, or natural life as it's called, sentencing provision did not come into effect until 1994. So he's ineligible for that. But they want you to consider it anyway, without telling you that the law that they want you to recommend probably would not hold up because it's unlawful. It did not come in Arizona, that law was not passed until 1994. But they throw that up there to say, see how reasonable we are? Not only did we come here and lie to you a little bit about what happened at the crime scene, or maybe we didn't tell you everything, but now we want you to commute the sentence, and we want you to commute the sentence to something that probably you can't. But it did not become law until 1994. Well, what else do they tell you? Well, they talk about the felony murder aspect of this, and they talk to you about the fact that, the jury didn't find that this was premeditated, but we do know one thing. We do know that the judge found that he was the one that committed the killing, or that killed Mark Jones, and we also know that he admitted to you that he was the person that killed him without remembering. Can't have it both ways. If you're going to stand here and ask for remorse, you better admit what it was that you did. But he didn't stand here and tell you, I was the one that did it. I'm remorseful. I own it, but I don't know what I own. You can't go halfway into believing somebody. It's not, you can't have half the truth. If you only have half the truth, it's a lie. And that's for you to decide. And so what is it about this crime? What is it that we were talking about that they did not discuss? They tell you, proportionately speaking, this is not one of the worst crimes ever, without really talking about the crime. They tell you, it's not really that bad of a crime. I mean, there's other cases that are even worse than this one, without referencing the events in this case. You have the photographs to show you that what we're talking about is an old guy. You're talking about an old guy who was nice to the defendant. He helped him. He lent him money. He provided him advice on his business. It was somebody who was extending to the defendant or the inmate a helping hand. And what does he do? What does the inmate do? What does Mr. Towery do? Chops that hand off. That's what he in essence does. So how does he go about doing it? He does it with preparation, and he does it by bringing somebody else with him. They say, whoa, look how unfair it is. Mr. Barker's out there walking around. Yes, that's true. Mr. Barker was extended an offer. But did Mr. Barker do something for it? Yes, he did. He assisted the state by providing testimony at the trial. That's what he did. And they claim, well, he's a professional liar. Well, there were 12 people on the jury that believed him. He must have not been that much of a liar. But they're asking you now to substitute your judgment by calling him names. Let's start calling people names so that maybe they will feel sorry. They will have sympathy. Well, that's part of your role here, but it's not all of your role. And so with regard to him, Mr. Barker, he's also not the ringleader. And I can say that he's not the ringleader because I can look back to a week previous when Mr. Towery went into Jeff's Steakhouse and did the same thing. And the only thing that's in common between Jeff's Steakhouse and what happened in this murder is this individual here and his zip ties, the zip ties that he used at Jeff's Steakhouse and a gun that he brought along. Oh, there's an accomplice in the first one, Jeff's Steakhouse, it's female, but there's also an accomplice here. And what you actually have here is the main actor. So that's why they are treated differently. He is the person that sort of grudgingly, hesitatingly said to you, yeah, I did the killing. I did the killing. That's why, because Mr. Barker did not do the killing. He's not the one that ended Mr. Jones's life. And Mr. Towery is the one that had the relationship with Mr. Jones, not Mr. Barker. And if that's the case, if he's the one that had the relationship, then he's the one that chose the mark. Doesn't look like Mr. Barker had any relationship with Mr. Jones. It was Mr. Towery. So what do we have then? We have Mr. Towery choosing the mark, Mr. Jones. We then have Mr. Towery bringing his zip ties, bringing his gun. Although he doesn't remember it, there is a syringe that's involved, and you've seen the photographs where there are those puncture wounds, so there is a syringe that's involved. Claims to not think there's any battery acid in it, but there's something in it, but we really don't know. He doesn't admit to the battery acid. And it's late at night. Imagine yourselves at home. It's late at night. It's 9 o'clock in the evening, and you're by yourself. And, you really don't have a means to defend yourself, and somebody that you know, somebody that Mr. Jones knew comes to the door. Doesn't have any reason to think that there's going to be anything that's going to go bad because it's somebody that he knows. And Mr. Towery used the confidence to his advantage. That's why Mr. Barker was allowed to take the plea and 10 years that went with it. And so then you get there and he's the one that's bringing the zip ties. He's the one that is bringing the gun. And quite frankly, he's the one that's bringing the what turned out to be the animus to kill. Because he talked about it. Yeah, that's something we discussed. And so they spent an inordinate amount of time there. How would you feel if somebody's holding you at gunpoint, 9 o'clock at night, someone that you know, and they start going through your stuff? Think that you would feel any terror at that time? You think you would be happy? You think you would be talking about a proportionate review at that time? How this case is different? How this case is really not above the norm? Is that what we're going to do now? And then in the midst and in the middle of this terror, Mr. Jones says, I gotta pee. I gotta go to the bathroom, guys, because I'm so darn scared. Those aren't the words. No one said that those are the words, but that's what happened. They scared the pee out of him. That's what happened. That's how scared he was. And the indignity of it. We have the bathroom that just went off just now. But can you imagine? Let's leave the door open so that one of you members can watch. The indignity of that while he relieved himself and was not even allowed to pull his pants up. Now the terror is escalating. It's gone for a long time, 2 hours, 45 minutes. And during that whole time, this old man who has that thing around his neck that indicates that he has a medical condition and cannot defend himself against this younger man, guess what? He needs to go to the bathroom. They don't even let him pull his pants up. Well, he lies to him and said, do you want to go to sleep? Well, or do you want to, something else bad happen? Well, sleep is probably an option. Most of us, I would bet everybody in this room has gone to the doctor to get an injection. Doesn't feel good, and it's for a good reason usually. And so can you imagine his terror as he's getting that thing put into his arm? And you've seen the photographs. He is scared. Does that put it above the norm, this old man? Well, and then he even pretends to be asleep because he's so, he wants to live. Everybody wants to live. He wants to live. He's alone in his house. It's late at night. People are this guy's poking him in his arm. He says he doesn't remember it, but he'll own it. So then what does he do? Well, they take his shoes off, and then let's go ahead and get this zip tie right around the neck. Could have shot him if he really didn't want him to identify him, but that would have made too much noise. Thinking man there. And so what happens then? Well, we brought a syringe that can be used, a veterinary syringe that can be used on a dog. Well, why don't we treat Mr. Jones like a dog? Let's play with him a little bit more. Cuts off the tie. You hear the gurgling that went on before, sort of unconscious again. Why do that? If you really just wanted to kill him, just leave the tie on and walk away. No, had to cut it and then put another one. That is absolutely cruel to the individual that's receiving that. And then additionally, it's absolutely heinous. It's depraved. It goes beyond the norm. And this individual is not an individual that comes to you without any exposure to the system. It's an individual that comes to you with a total exposure to the system. He's been in and out of prison. He's been granted probation. He's been granted parole. He's violated all that. And while he's on parole, he commits these crimes. And approximately a week before he killed Mr. Jones, he again is committing another armed robbery. And so now this, to use their term, victim comes before you and makes, according to them, 5 arguments. They say, well, at the time of the killing, he was significantly impaired, and that's the psychiatrist. They don't tell you that at the time, and it should be the same now, his IQ was 116, his verbal IQ, his abstract was 104. That's a man that can plan. It's a man that can say, you know, if I pull the trigger, it'll make a loud noise. I don't want people to come in here. And so they're saying that, you know, this is something that he should be given credit for because somebody else was standing there. But if you're going to look at that, let's add up and see what it was that he did, what this person did. We've talked about it. He's the one that actually killed him. He's the one that brought the gun. And he's the person who did the other armed robbery. And I keep going back to that one because to show that the only constant between those two is him and his zip ties. Well, they say to you, this is not the worst of the worst. Well, if this isn't the worst of the worst, what is? If we talk to Mr. Jones, if you could talk from wherever that he is, what do you think he'd say? Yeah, that's what he would say. It is pretty bad. 2 hours. 2 hours must have seemed like 20 lifetimes to him. And then to put that around your neck, gurgle, feel the life go out of you, then be brought again. Well, they say that he has served his sentence here peacefully and that you should give him a bonus point for that. And that you then, of course, should commute the sentence from the death sentence to a life without the possibility of parole. Most of you are familiar, I'm sure, with the death row accommodations here. There isn't much room for somebody to misbehave. So I also side with the Arizona Supreme Court when I say that if somebody cites that they have behaved in prison, that's expected. So you don't get any bonus points for just doing what you're supposed to do. But again, since he's the victim, they want you to consider that. Well, they also talked to you about the mental illness, and somehow that wasn't raised at the time. It wasn't raised at the time because it wasn't something that existed at the time. It's not a condition that he had. And so finally, you're left with this sort of statement that you can remedy the fact that some mitigation was not presented or that the judge could not consider some of the childhood mitigation because it didn't have a nexus. There was no connection to the crime, and that somehow somebody missed that, and you can now right that wrong. Again, let's go ahead and change the rules for this person. Change the rules for this person so that, you know, left is now right and up is now down because it's him, and he happens to be here, and he happens to have been in the state's evaluation less than credible of what he presented to you. It's a difficult choice with these cases that you always have, but this case has been made, I think, if not easier, a riddle that's a little bit easier to solve, because by his own words, he has indicated to you that he has been less than forthright with you. He has shown that, as part of his admission, that he was the one that actually killed this individual, and all you're left with is the idea or his request that you now consider him a victim, and that you consider him a victim. Why? Because he said so. I ask you not to do that. I tell you that right is right and justice is justice. And 20 long years have gone by now where
Yes, Carol. Carol asked if this is just a reminder of what we're watching right now. And this is a hearing taking place, I think, about a week or so before he's meant to be sentenced. Well, not sentenced, meant to be executed. So this is the final hearing in an attempt to put a permanent stay to the execution.
Everything has been examined. The law has been followed to a T. And I ask that you not buy into this notion that he's a victim, and I ask you to not commute his sentence. And I know one of the things you may consider is a reprieve. I also ask that you not consider that. Thank you for your time.
Thank you, sir. I just wanted to, before you leave, I just wanted to make a point, and the issue has been raised at previous hearings regarding the board could not recommend and the governor subsequently grant a commutation to life without the possibility of parole. I must disagree with you with that particular point. I think our governor's powers of executive clemency, the governor could say you can go home if the board recommended it, and he could go home. That's how far the governor's powers of executive clemency reach. So I want to say that also for the board's understanding that I don't believe it's correct that this board could not recommend life without the possibility of parole and it be granted and it be in fact put into play with him. And I'm not an attorney, and I'm not saying that to debate or whatever. That's just my understanding of the clemency powers of our government.
Right, and I agree with your position, and I think we had the same discussion when we discussed Landrigan.
We did.
And my point was that there was a rule in place back when he committed the killing, and that is that life without the possibility of parole did not exist. And I know that the board has a wide range to recommend things that may not have been available, and I do agree with that.
Yeah, because even if a person was doing natural life, which we all understand to mean the rest of your life, if they come in front of the clemency board and the board says, we don't think it should be natural life, Governor, we think that he should be given a bottom number or a parole eligibility date, the governor's powers of executive clemency could in fact do that. But anyway, thank you for that information. Mr. Lusota.
Yeah, I have a question about the, what was that, the actual murder weapon? You've described it, and it's usually described as zip ties, which to me are plastic.
Correct.
And capable of being cut off, as was indicated, happened after the first incident of strangulation. But Mr. Towery has described them as metal and said that they had been used to wrap other things up, and they weren't. What have you ever seen them?
Actually, you have a photograph of them. They are plastic. I don't remember whether or not Mr. Towery described them as metal. I think he may have indicated that he used them to tie metal with them.
Exactly, as a tie wire.
As Red suggested, Red, our wonderful mod, for those of you who are new here to this channel for the very first time, what we do is cover pretty much up until this point exclusively Louisiana Parole Board parole hearings and commutations, but because this is a 20,000 subscriber live stream, we're doing something that is different. But typically it's all Louisiana parole board and commutation hearings. And thank you. Welcome to the chat. If this is your first time here.
Make them a wire tie.
So you could cut them with
some kind of
absolutely. You can cut metal too, but stuff. Okay,
but much more easily you could cut the zip ties. Correct. Which would have implied that he had some utensil to cut that with, a knife, scissors, something like that.
Thank you. Anything else, Mr. Russo?
No, sir.
All right, thank you. Thank you, Mr. Martinez. And now I'm going to extend a call to the public. Any members of the public wishing to address the board regarding this matter that is in front of us regarding Mr. Robert Towery. And if you do, you can move up to the podium at this point. Anyone wishes to?
Chairman Belcher, members of the board, my name is Dan Peitzmeyer. You may get tired of me coming before you. I'm not excited to come before you, but as long as the state continues to execute, I will come to protest. Two friends of mine were recently murdered. I've heard Mr. Martinez talk about the brutal act that Mr. Towery committed. I abhor the act. I abhor the loss of Mr. Jones. But the reference of the murder of an old man struck home to me because Albert Kiwis was 90. His wife, Sophie, was 87. Their home was invaded in November of 2010. They were beaten, gagged, and left to die. Our county prosecutor, Mr. Montgomery, chose not to seek the death penalty for the defendants. I applaud his decision. I only bring this up to show the arbitrary and capricious nature in which the state chooses to execute. I stand before you asking that you recommend commutation for Mr. Towery. Thank you.
Thank you, sir.
Thank you, Mr. Chairman and members of the board. My name is Emily Skinner. I'm with the Arizona Capital Representation Project. The 1991 death of Mark Jones was senseless, tragic, and cannot be minimized. As you've heard here today, Mr. Towery has publicly accepted full responsibility for his role in Mr. Jones' death, and he faces regret and remorse each day he spends in solitary confinement. Strikingly, his equally culpable co-defendant, Randy Barker, has spent each day for the past 11 years a free man in exchange for his testimony against Mr. Towery. This, despite that Barker was equally responsible for planning and orchestrating the robbery, assault, and murder on Mr. Jones. While Arizona tolerates some legitimate disparity in capital sentencing based on individual culpability, the facts of Mr. Towery's case are truly unusual and disturbing, where Barker served 10 years and Mr. Towery faces lethal injection next week. These facts set Mr. Towery's case well apart from other cases this board has reviewed and begs for this board's remedial action against the arbitrary application of the death penalty. Mr. Towery's mental illnesses stemming from his traumatic childhood further support this board's exercise of mercy. As a boy, Mr. Towery experienced unspeakable and persistent violence at the hands of his mother. He was no safer outside his own home in his community, where he was sexually assaulted by a neighbor. He experienced a series of abandonments by his biological father, his stepfather, and his mother. According to experts, Robert Towery's childhood trauma was so severe that it resulted in post-traumatic stress disorder, major depressive disorder, and substance abuse. Mr. Towery was suffering these serious mental illnesses at the time of his crime, but a series of failures by court-appointed counsel resulted in the judiciary never hearing the full extent of Mr. Towery's devastating childhood and his mental illnesses. In the modern history of the death penalty, governors and clemency boards have routinely granted commutation where a death sentence is disproportionate when compared to the sentence of co-defendants. Since 1977, there have been at least 7 death sentences in 3 states that were commuted to based on the lesser sentences imposed on equally culpable co-defendants. Similarly, the striking disproportionality of Mr. Towery's sentence calls for commutation to life. A death sentence is not justified here. Mr. Towery was extremely mentally and emotionally compromised at the time of his crime. Arizona has shown extreme leniency to his co-defendant, Randy Barker, who walks as a free man today, while Mr. Towery faces the ultimate punishment. I strongly urge this board to recommend commutation.
Thank you.
I'm Robert's sister, the middle child, and this is
I'm Patricia, the oldest child.
and I just want to clarify something. I know that you have all the records in there about what was said on what we testified in the trial about the abuse. The gentleman that was up here earlier who wanted to know about proof and evidence on that is why I'm standing here today. It wasn't mild child abuse that we went through. And post-traumatic stress syndrome has affected all of our lives. Fortunately for she and I, we had mentors in school and people that could come to us and help us get through that time of our life and put it aside. My brother, unfortunately, was befriended by people that were from the dark side and took him down the wrong road. I personally connected with Mr. Jones's sister gave her a sympathy card. She gave me one at the time of the sentencing. We exchanged Christmas cards. I in no way think that what happened to him is justifiable under any circumstance, whether it be drugs or anything. However, anyone using drugs, and to that degree, you had made a comment about why should he be treated any differently. I firmly believe that anyone who's got that kind of an addiction and that kind of a background does need our help as a society and not to be murdered. To the extent of the abuse, I will tell you this, on occasion, weekly, if not daily, we were all beaten to the point of bleeding, bruising, and blacking out. If he doesn't remember part of the crime, I wouldn't be surprised if he didn't black out during that high state of emotion, because we did. My mother said, I hate you. I wish you were never born. I wish you were dead. We walked in large circles around her so not be hit. We were grateful for the station wagon so we could get all the way to the back. We were woken up from a sleep with a belt or whatever was going around because we forgot to put something in the dishwasher. This is fact. I am attesting to it. So the gentleman who didn't see any evidence of it, I'm showing you the evidence now. I said it before. This is God's truth. The woman was crazy. When we left and he was left alone with her, she proceeded to put pressure on him to take care of her in any way means possible. She knew what he was doing, and she would put the money behind the cupboard, knowing full well where it came from, encouraging his activity. That's not a mother, not helping him. But if there's any doubt about the degree of abuse that we suffered at the hands of our mother, and if anyone has the question as to why we didn't come forward, our mother had us so afraid from the time we were young that we would be killed if we told anybody, and we believed her. There's evidence my aunt put into the documentation that we were beaten as 1- and 2-year-old naked babies in the bathtub for being too noisy. My mother held scissors at my throat and told me she would kill me if I didn't tell her where I was. So it wasn't normal abuse. This was incredibly horrible abuse. And did it mess with his head? Absolutely. And he had no one that came to his side. Thank God I did. Thank God she did. So I wanted to make sure that his testimony, where there was no evidence, that there is clear evidence. Did that lead to post-traumatic stress syndrome? How could it not? How could it not? There are times in my childhood I don't remember. There are times I remember vividly. And between the three of us, we could paint a picture that's a horror movie. And we didn't go to anyone, and we didn't get help because we were afraid of our lives. Afraid for our lives at the hands of this woman. So when he was left alone with her and had to take all of it on himself, there's no doubt in my mind that that drove him beyond anything normal. All I wanted you to know is it was true. All true, very true.
Thank you, ma'am.
I would also like to add a point of clarity, as my siblings have stated. And I'm so happy that the prosecutor grew up in a good home with a loving parent who wasn't hiding behind doors, forcing them to drink Listerine when they came home with tonsillitis at the age of 8. I'm so happy for him that he doesn't have to bear the history that we bared as children. When we paint our picture, as my sister said, she has memories that I don't have. I have memories that she doesn't have. And we both have memories that my brother doesn't have, and vice versa. And why is that? That's because we were so bound to survive in our own little world. My sister and I built rooms in our closets to hide in. I was surviving myself. She was surviving by herself. And poor Robbie was the youngest one and had no one to protect him. And I have lived my whole adult life and will go to my grave, hopefully at an older age, knowing I didn't help him, knowing that I was too afraid to step out of my closet and take care of him when he was young. And yes, he was a bedwetter. He was hooked up to electric machines that would sound alarms in the middle of the night when he wet the bed. I was well into high school. He was a child of 10, 11, 12, 13 years old, hooked up to machines that would go off in the middle of the night because he wet the bed. So, Mr. Attorney, Mr. Prosecutor, I'm so grateful.
This address the board if you will.
I'm sorry. I'm grateful for everyone who had a normal childhood, a very normal childhood, because we did not. And I invite anyone to come and explore our world, because it is, as my sister said, a true horror story. And where is my mother today? Once my brother was arrested, my mother committed suicide in the most horrific manner, because she knew all of this would come to light. She knew she would be brought forth and the secrets of our childhood would be brought out. So she's not here today at all. She's not here to defend herself by her own choice. Thank you.
Thank you, ma'am.
Did you
I'm
ladies
sorry.
testify at his trial?
Yes, sir. Yes,
Thank
we
you.
both did.
Is there anyone else that wishes to address the board from members of the public? All right, hearing none. Is there any final comments that
someone-
either Mr. Towery or, oh, I'm sorry.
Mr. Chairman, members of the board, my name is Inge Casey, and I'm here today to speak to you on behalf of Pax Christi Phoenix. Pax Christi is a Catholic peace movement in the tradition of Jesus, Gandhi, and Martin Luther King. We abhor violence in all its form, and in that sense, we definitely condemn the murder done by Mr. Towery. We are very much aware about the pain the family, and actually both families, went through in the 20 years he was there. However, we understand that we need to keep society safe, and keeping Mr. Towery in prison for the rest of his life would do that. But none of this has taken away from the humanity of Mr. Towery, of Richard. The humanity every person has. We, the members of Pax Christi, believe deep in our hearts that the state has not the right to take human life. As Sister Helen Pashan, the author of Death Men Walking, who recently visited Phoenix and Arizona, reminded us, the death penalty does not make us safer, and the death penalty does not help the victim's family heal faster. You, the member of this commission, have the opportunity to show mercy to a troubled human being. I won't repeat what you just heard from testimony of all kinds. I'm asking you to look deep into your hearts and see if it's really doing justice to execute Richard. Some of you occasionally pray and forgive us our trespasses as we forgive those who trespass against us. There's nothing in this common prayer that talks about the size of the trespasses we are to forgive. I urge you, I beg you, I implore you, please grant Richard's request for clemency.
Thank you, ma'am. Saying no one else, is there any final comments, Mr. Bates or Ms. Day? Either one.
Mr. Bates is going
Okay, thank you.
Chairman Belcher and members of the board, thank you for giving Robert the opportunity to be here today and for listening to his statement, our presentation, and the witnesses we presented. You now have the responsibility to weigh what we submitted to you in writing and what we presented here today. The presentations and materials by the state, as well as the other materials that you have before you. The question before the board today is whether to recommend to the governor that she show mercy in this case. I would briefly like to comment on some of the statements made by my friend Juan Martinez. Yesterday, we submitted a supplemental letter to the board correcting a misstatement in the written submissions that he made to the board. What he neglected to point out in his presentation was that on page 4 of the statement, he said that the hypodermic needle contained battery acid. That's contrary to what the trial prosecutor said during the trial, where he admitted that the state may not have shown that the substance was battery acid. Briefly, I would like to point out some of the misstatements he made in his presentation today. Robert did not say that the armed robbery at the steakhouse was his girlfriend's idea. Robert accepts responsibility for that armed robbery and for the robbery and murder of the victim, Mark Jones. Mr. Martinez said to discount much of the evidence of substance abuse and child abuse because it was self-reported. Well, you just heard from his sisters. People who knew Robert and the co-defendant knew the amount of meth that they were doing at the time, and that was also reported. And as Mr. Martinez agreed with Chairman Belcher, this board does have the authority to recommend to the governor a commutation to life without parole. The juror who you heard from, someone who sat through the trial, said it was unclear to the jury who did what. But what we have is Robert today admitting to you that he is responsible for the death of Mark Jones. And I submit to this board that his behavior in prison is relevant to a life sentence. Mr. Martinez invoked comments by Justice Feldman in the direct appeal opinion in this case. I would like to direct the board to statements by Justices Ryan and Hurwitz in the Gallardo case, an oral argument that was before the Arizona Supreme Court, where Justice Hurwitz was asking about the conduct of the trial prosecutor in that case, the trial prosecutor being Juan Martinez. And he asked, short of reversing a conviction, how is it that we can stop this inappropriate comment? Justice Ryan, who was a former county prosecutor, a Superior Court judge, a judge on the Court of Appeals, and a justice on the Arizona Supreme Court, said, I recollect this prosecutor from several cases. This same prosecutor has been accused of fairly serious misconduct, but ultimately we decided it did not rise to the level of requiring a reversal. He went on to say, there's something about this prosecutor, Mr. Martinez. And I suggest that this board view the statements made here today by the Deputy County Attorney through the lens of the observations made by Justices Ryan and Hurwitz in the Gallardo case. The American system of justice is based on fairness, mercy, compassion, and humanity. This board has the duty and awesome responsibility to ensure that justice is tempered by mercy. And as this board knows, a commutation of the death sentence to one of life in no way relieves Robert of most of the legal consequences of his act, nor of moral guilt. There are 5 reasons to recommend mercy in this case. First, the disproportionate sentence Robert received compared to that of his co-defendant. Second, Robert suffers from significant mental illnesses that had an impact on his behavior at the time of the crime. And I refer you to Dr. Stewart's presentation. Third, the courts did not consider mitigating evidence at the time of the trial because the lawyer did a poor job in presenting it, and the judge felt constrained by the law at the time to consider it. Fourth, Robert's death sentence is disproportionate to life sentences imposed in other murder cases where the crimes were more worse. Ms. Merle addressed that in her presentation, and we provided the board with ample support in the application that we submitted. Robert is not the worst of the worst. And fifth, Robert would serve his life sentence peacefully and productively. I would like to take a final minute to talk about the disproportionate sentence. Robert's death sentence is disproportionate to the 10-year sentence imposed on Randy Barker, the co-defendant. Under Arizona law, Mr. Barker was equally culpable for the murder and robbery of Mark Jones. Mr. Barker made a plan to rob with Robert, and he held the gun on the victim while Robert strangled Mark Jones. There was no plan to kill. There was some discussion about it, but they did not go there that night to kill Mr. Jones. The murder was an inexcusable act, and both men are responsible. One is free today after serving a 10-year sentence. The other is 6 days away from being executed. Robert is not asking for this board to commute his sentence to time served, already twice the amount of time that his co-defendant served. He is not asking to have his sentence commuted to a term where he would have an opportunity in the future to come back before this board and ask for a commutation or parole. No, he is asking this board to recommend a sentence of life without parole. Still a harsh sentence when compared to that of his co-defendant, Randy Barker. What will be accomplished if Robert is executed next week? Will the citizens of Arizona be any safer? Mercy has always been a primary and proper purpose of clemency. Retribution demands that an offender receive the punishment he deserves, no more and no less. Mercy is understood as the partial or complete remission of deserved punishment. Mercy therefore tempers the demands of retribution. So today, Robert Towery is appealing to this board for mercy. Thank you.
Thank you, sir. We are going to make a decision in this matter, and we will may or may not have board discussion, and then we will entertain a motion and go from there. Is there any discussion? The one Per the request, the only thing that we are considering today is a commutation of sentence and not a reprieve. So is there any board discussion regarding the issue of commutation for Mr. Towery? Is anyone that has any comments on the position?
Well, Mr. Chairman, thought a lot about this case and listened intently to everything I could. And I have to say, I come down on the side of not favoring a commutation to Mr. Towery. Some of the things that were said today helped convince me of that position. Obviously, a very difficult upbringing, an absolutely sadistic, evil mother, as testified to eloquently by not only Mr. Towery, but also, well, less so by Mr. Towery than by his sisters. But Mr. Towery, the times he was incarcerated, got away from some of the traits that Dr. Stewart just testified that he possessed at the time of the killing. When he was away from forbidden substances or the kind of substances that get abused, he behaved well. In fact, he got a ringing endorsement from the Louisiana people during the time he spent there. He was in business in Phoenix for over a year. I believe that would be the case because he was out on parole for about the last year and a half before he committed the two crimes that we've talked about here today. And he said he knew Mr. Jones in that business at least a year, during which he was presumably, from at least from most appearances, pretty law-abiding and was a businessman. Sure, he was using meth. He must have been using it all the time. We don't know what the dosages were, but we do know that about 10 days before the seminal crime, he commits, as Mr. Martinez has said, a somewhat similar robbery crime. We've heard no testimony about why that was necessary. Was his business failing? What was going on in his life? But he commits a robbery and, apparently encouraged by the results there, soon starts planning, along with Mr. Barker, to do some damage to Mr. Jones. They do discuss the possibility that they may have to kill Mr. Jones. Mr. Towery has admitted that. So that was within the context of what could happen there. I'm sure they did not go to the house intending to kill Mr. Jones, but they did go to the house knowing that in the course of committing a serious robbery and getting away with it, they might have to kill somebody, presumably Mr. Jones. That really troubles me. And his behavior at the scene isn't, from the testimony of Mr. Barker, but also from objective evidence, is consistent with someone who is thinking rationally. For example, he has a discussion with Mr. Jones about who might be coming over soon. He has he makes what we described as small talk with Mr. Jones, and he spends 2 hours going through the house looking for things that a thinking thief would look for. I dare say everybody who commits a crime like this isn't fully thinking rationally, because they're different from you and I and probably everybody else in this room. And we don't think that way. We don't kill people. But I don't think he was so afflicted by a mental disorder at the time that he was incapable of thinking about just what he was doing. He thought about the other thing that he thought rationally about has been pointed out is the use of a firearm. And he thought quite rationally that a gun makes noise and zip ties don't. That to me is rational thought product. I'm not convinced that he was under the dire influence of all these evil things that had occurred to the man in a very wretched environment up to through childhood. And I'm not. I also think that there's a little proving too much that goes on here today. Mr. Barker is the consummate bad guy. Mr. Barker, as Mr. Bates and his cohorts know, was not eligible for the death penalty. Never was, because he wasn't the actual perpetrator. He wasn't the killer. Under Arizona law, he's a felony murderer, just as this man was. He could have been a felony murderer, but he was not eligible for the death penalty. The prosecution has to make decisions every day about who to go after in situations. And it's very easy for all of us, as many have testified here today, to second guess what happened here. I don't second guess it. The prosecution, we also don't know about the criminal history of Mr. Barker. It's not been discussed. We do know about the criminal history of Mr. Towery. And we do know that Towery, that the state of Arizona punishes people who have committed serious felonies before more severely than they punish those who don't. There's built-in disparity. Secondly, and I think it's to a large extent appropriate. Do I think Mr. Barker should have gotten more than 10 years? Yes. But do I think there's this wide disparity? It's a disparity, by the way, that is promoted by the defenders of Mr. Towery by saying that he should get a life sentence without the possibility of parole. A sentence that in normal actuarial tables would probably say would be a 40-year sentence. He probably has at least 20 more years of natural life left in him. Under that, so and they're decrying disparity at the same time. They're promoting a sentence that would probably be 4 times greater than the other fellow got. Well, part of the reason is that's the way things work, and the other part of the reason is the other fellow was not eligible for the death penalty. It's easy in these cases to blame all sorts of folks. All 3 lawyers, sets of lawyers, it seems to me, who have previously represented this man, came in for some obloquy today. I just think that under the circumstances, this crime was one of the worst of the worst. And when he perpetrated this crime, Mr. Towery was one of the worst of the worst. And there isn't enough here to justify a commute. So I'm not in favor.
Thank you. And I just a quick comment. I don't know if I concur with the fact that Mr. Barker was not eligible for the death penalty. I don't follow that, but I do agree that, and I've felt this way a long time, that one basically turns state's evidence, even in some cases, is worse than the one that gets the ultimate punishment. And I think that's the way that the system works. I disagree with it in a lot of instances, but it is what it is. It is what it is. But I feel in the way of, I feel that there was some intent going in to commit a murder for the simple reason, if you could ration that the gun would make too much noise, you can also ration that the victim in this case would be able to recognize who robbed him because he knew him. Yeah. So if you leave him there tied up or whatever the case might be, he calls the cops. Somebody comes and finds him and says, it was Mr. Towery and the other gentleman that robbed me. I know him. I worked with him before. So I have some issues about that. If there's...
Well, Mr. Belcher.
Yes.
I just wanted to make the comment. I would agree. In talking about, we heard some of the aspects of the crime, but it just seems so convenient that we don't remember what happened with the syringe or even remember there was a syringe there, and only Mr. Towery really knows what was in that syringe. And today we couldn't hear that. I'm not quite understanding why that particular aspect of this moment when the crime occurred, why this part can't be remembered. I've listened to the psychiatrist, but the other details can. So I would agree with Mr. Lasota.
All right, if there's no other comments, I'll entertain a motion regarding the application for a commutation of sentence for Mr. Robert Towery, 51550.
My motion is not to recommend clemency to the governor.
Ms. Kirschbaum submits a motion, seconded by Mrs. Wilkins.
I agree.
I agree.
Stinson agrees. Mr. Lasota agrees. I agree. By unanimous vote of the board, this case will not be recommended to the governor for clemency. Thank you all for your participation. That concludes the hearing.
Well, that was the end of the hearings, and now what we can do is go through some interesting information that I found in this case, but basically we'll fast forward that he was executed just a week later, March 8, 2012. He was pronounced dead at 11:26 a.m. At 47 years of age. Now, what he had done, he was convicted of killing the 68-year-old Mark Jones in 1991. Mark Jones was a really special guy. He was a philanthropist, and he was known for sponsoring needy kids for college scholarships. And he was just a really giving guy, one of those very unique giving people. And as a matter of fact, he gave Robert Towery money. And it really was a shame that he had to have his life taken. Now, whether you believe in the death penalty or not, whether you believe he should have been given the death penalty, there are certainly things brought up in the case that are interesting. They were saying, well, his co-defendant only got 10 years, and meanwhile, he had gotten the death penalty. And really, my argument would be is, why did he give his co-defendant only 10 years? Did you really need him to testify to get the conviction? Apparently they thought so. Here's something interesting that we found, which is he had like a diary that he wrote for the final few days before, I think 30 days before his execution. And what's interesting in here is not so much about even what he writes about, but it's what he doesn't write about. It's very mundane. There's very little depth in his writing. And there's really no mention of guilt. There's no mention of really regret. There's no mention of the victim. There's no mention of any of it. It's just really, we can go through it. February 2nd, he writes that he apologizes about the messiness of his letters. He complains really about the fact that they don't allow him to have glasses. He complains that this TV is pushed up against the sail. It's far away from him. On February 3rd, he writes, and I'll put the link to this in the description so you can read all of it. But he basically talks about, and I know it's hard for you to see this. I don't know why I can't get it into full screen. It's really quite frustrating. But he shows a lot of there are multiple cases where female officers were guarding him, and he's very insulted by that. He felt that was beneath him, which I just, I don't know what that's about. They stripped me out with the female officer present. Now, personally, I'm not the shy type, but having a female officer on death row watch is just one more humiliation. That's what he says. Anywho, as I come out to the nurse who was taking my vitals, they also take my temperature and pulse. They don't know why they're there. They take a shower. And he just talks about these things. February 12th, 5 a.m. Oh my gosh, now a nurse is here. Bob Mormon was feeling a bit out of his blood sugar. Oops. And it just goes on and on. February 13th, one more observation for me. It's a good one. I have not seen a single roach. We bring up the roach, water bug, scorpion, beetle, spider. Woohoo! Over on the other side, I live next to the rec pen. I went on a safari. February 15th. Okay, this is funny. Exactly who is watching whom. I'm sitting here watching the news and it happened to glance and see that COs had their heads in their chin. February 16th. They called ICS is wrong, Bob. He had told the nurse this morning, so he's talking about a fellow death row inmate. February 18th. So again, this is the final diary up until his death, and it's just quite mundane. Like I said, there's no mention, or there's nothing really insightful. There's nothing, no mention of sadness. There's no mention of regret. Here's the final March 8th, 7 a.m. Good morning. Well, I actually slept well. I woke up at about 5 a.m. I was given a donut in a very large container. The orange juice was great. First orange juice I had. The donut was prison issue. Enough said. I just finished my visit with Deacon Ed and receiving a communion. Now I am waiting, y'all, at which point I'm going to have to give you my legal work and my Bible. Please give my Bible to, the name is blacked out. As this is my last entry, I just want to thank you. Thank you for your kindness. Please give everyone my best, and will carry y'all's on my lips to God. My best wishes to you. Take care. So, I don't know what to take from that, but then he was executed. And you can get all this, it says on Kindle or Amazon if you want it, but I'll also drop the link. Here are the different pictures of him throughout, I suppose, his time in prison. And here it was. The chamber that he was ultimately executed in. The final words that he said when he was executed, we actually have that written down. Where is it? I think it's here. Final words. So he did have final words that he said. So he apologized to his family and to the victims. He talked about the bad choices he made. And then he said, as he appeared to be crying, I love my family. And then he said, potato, potato, potato. His reference to potatoes was a message to his nephew who witnessed the execution and referred to the sound made by a Harley Davidson motorcycle. Maybe like the engine. Boom, 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 boom. Towery's attorney, Del Beach, said it was Towery's way of telling his nephew that everything is okay. His final meal was porterhouse steak, sauteed mushrooms, baked potato with butter and sour cream, steamed asparagus, clam chowder, Pepsi, milk, and apple pie with vanilla ice cream. Now, I do believe, agree, he went there, you have to think, with the intentions of murdering him because he knew who he was. So then, the question about what was in the injection, was it battery acid? And he came up there and made a statement that he's a licensed mechanic. There's no such thing as battery acid. Jesse, you're a mechanic. Is there such a thing as battery acid? We had someone else who came here and commented that there absolutely is, especially in the 1990s when this crime took place. I know that I have had batteries that I could hear liquid shaking inside. I don't know though, but he testified that there is no such thing as battery acid, so it couldn't have been. We do know factually that the prosecution couldn't prove that it was battery acid. But the bottom, Tracy says there is, yeah. And Jesse says there is. So, and from what I Googled, I've seen that there is also. I asked ChatGPT and they answered to me that battery acid and batteries, this is the answer. Acid as it remains is an effectiveness, reliable option for powering vehicles. Wait, it's battery acid, also known as sulfuric acid, is often found in lead acid batteries. Lead acid batteries are commonly used in vehicles, boats, and other machinery that require a source of electrical power. Sulfuric acid in these batteries serves as an electrolyte, which helps facilitate the chemical reactions that generate electricity. Yeah. Yes. Yep, sulfuric acid, you're right. So I don't know how he can get up here and testify that there's no such thing as battery acid when it seems to be commonly when it seems to be undeniable that there is such a thing as battery acid. But he did. So what happened is that he laid him down on his bed and he said, "Do you want me to tie you up, or do you want me to give you an injection that would put you to sleep?" His victim said, "Put me to sleep." So he injected him, and then he was smart enough to pretend to fall asleep. So he pretended to fall asleep, and that's when they suspected he was pretending, and they choked him. And they thought they choked him to death, and he was astute enough to pretend that he was asleep and not aware that he was being choked. If you can imagine what he had to do to put himself in that state. And they realized that he wasn't actually dead, so they choked him a second time, and that time they had killed him. You know, whether you believe in the death penalty, I mean, they brought the defense did bring up, I thought, interesting scenarios where they brought up examples of much more horrific crimes where death penalty wasn't given. They brought up the fact that the judge, not a jury, decided whether the death penalty would be given. I agree that it's ridiculous that his co-defendant only received 10 years, but I wouldn't view that as a deciding factor as to why he should or shouldn't be given the death penalty. You know, the death penalty, I do believe, should be reserved for the worst, and certain people should receive it. Someone who goes into a school and shoots up a bunch of little kids should not have a right to be on this living earth, in my opinion. And it should be up to the victims, in my opinion. Now, it does cost a lot more money to put someone to death. And so you can't argue the financial aspect. But something else that we've learned watching almost 500 hearings in Louisiana is that a life sentence does not mean life anymore. How many life sentences for people who have committed crimes more horrible than this one, much more horrible than this one, that have gotten commuted, that have been set free? So that is the one of the things that I've learned, which is if you're going to have the argument as as to, well, why be so vindictive? Why take his life? Just let him be locked up. You could say, well, I can show you dozens and dozens of cases where someone is set free, where they had gotten the death penalty, had it commuted, and then been given parole. So you could argue that. Now I thought his sister spoke elegantly and quite and really well, and I feel badly for them. And it is also interesting to see that they seem to have done well in life, and he hasn't. And it's very clear that he had a terrible life, which you can argue could be mitigating circumstances. I don't feel strongly about him being given the death penalty. I would have been okay with him spending the rest of his life in prison, frankly. But not because there's empathy for him, but I mean, maybe for his sisters. But we are, I think, the last first world country in the world that still does give the death penalty, and I think it really should be reserved for the worst of the worst. But again, that is just my opinion and my thoughts. But we've been here now for 3 hours, and I want to thank all of you for joining this live stream, and it is the 20,000 subscriber live stream, and I appreciate all of you who've been such a huge part of making this channel grow. And as more and more time goes by, the passion remains or even strengthens. You know, I couldn't imagine when I first started this channel that more than 10 people would ever subscribe. And because of you, I kept going because you encouraged me to do it. And we learned so much together. We learned so much about our system. We learned how corrupt our system is, how broken it is, how victims, survivors are left ignored and neglected by our system. We learn so much. And through that learning is really what keeps me going. We literally had the Attorney General of Louisiana fight to shut this channel down, and they did shut it down for a while. The DUI guy came in with like a superhero to save us, but I didn't think we would be saved. I mean, who wins? How does a little channel like us beat the state of Louisiana and YouTube, right? But I like to say it was meant to be. And I intend to keep on doing this as long as I can. And really, it's your support, your comments. When I see survivors share their stories and share their experiences, this is what I went through. And then I see everyone jump in and share support and share their mutual stories of pain and suffering and abuse. And then how everyone comes together. Those are the things that really keep me going as well. And there's so much love and respect. And like I said, like we say here in this channel, we're not an echo chamber. It's so important that we have varying opinions, even strong opinions, but that we respect each other's opinions. We can learn from each other. It's okay that we do. Actually, it's not just okay. It's what we respect of each other, that we don't agree on everything because we don't want to agree on everything. And I'm often switched up. I can read comments and change my minds for certain scenarios because people make really great points. And yes, I have a Winston Churchill cup on my desk that says never, never, never surrender. And he is my hero, Winston Churchill. And we'll fight on the beaches, on the landing grounds, on the hills, and the streets. We will never surrender. But with that, I will let you go. Much love and respect. Thank you.